Good morning. Thank you, Kevin. Morning, everyone. Welcome to the second day of our Detroit case call. I'm honored to be joined by my good friend Judge Kelly and my soon-to-be better friend, now that I know what kind of car he drives, Judge Ackerman. In all seriousness, we've had an opportunity to review the materials that you have submitted to us. We've had an opportunity to discuss them amongst ourselves. So if you could narrow your oral arguments to those issues which you feel are deserving of our attention today, we would greatly appreciate it. If you want to reserve time for rebuttal, please let me know in advance. Kevin is our bailiff today, is our official timekeeper. If you're starting to get close to your time, he pulls out his service revolver. When you're at your time, he aims it at you, and you don't want to know what the next step is. But we do take the time limits quite seriously, as does Kevin, because he has plans later today. That being said, let's begin today's call with item number 16, case number 371-586, People versus Arnold. Both parties are endorsed for oral argument on this case. Sure, go ahead. Back to your own stomping grounds, huh, counsel?
I am, Judge Burke. I am.
Well, welcome home.
Thank you. Good to see you. May it please the court, Kirsten Nunn from the State Appellate Defender's Office on behalf of Gerald Arnold, and I would like to reserve 3 minutes or so for rebuttal.
All right.
Given that this panel has thoroughly read our brief, I am going to primarily just focus on the one issue that I think needs to be expounded on a little bit more as it relates to Mr. Arnold's conviction for the felony firearm that was related to the second-degree murder acquittal. The people do concede that that particular account that trial counsel was IAC and that should be vacated. So I don't, unless the judge or any one of you has questions about that particular issue, I was just going to kind of move on to the next issue that I think is a little bit more in need of explanation.
I don't have any questions.
I'm going to move on to the next issue that I rose that the people don't concede on, which would be issue 3, having to do with the inconsistent verdict result that we ended up with in this case. Now, in this case, Mr. Arnold was initially charged with second-degree murder and felon in possession of a firearm, and then there were 2 felony firearm counts that were attached to each of those. It is our contention that this inconsistent verdict that we came out with was the result of juror confusion for the reasons laid out in the brief, and I'll just briefly kind of highlight some of those. During deliberations, there was a series of questions that were posed to the court by the jurors that kind of, I think, fleshed out that they were unsure about exactly how the statements that, how the law was to be applied and, what charges were, went to what count, how to apply the law to each of those counts. At one point, they were even hung for, a minute. They said they were hung on 2 charges, and they, I guess, had a decision on the other 2. The judge told them to go back in, continue to deliberate. They went back in, continued to deliberate, and they came back with the result that they came back with, which is ultimately an inconsistent verdict. Now, obviously, we are aware that the law does allow for there to be an inconsistent verdict, and just the mere fact that there is an inconsistent verdict in and of itself is not enough to, require a reversal. But there is law that says that, when that inconsistent verdict is the result of juror confusion or compromise, which I think we have a little bit of both here for the reasons I did lay out, that it is warranted that there be, a reversal. And again, I think in this case, because of the acquittal of the second-degree murder, where the jury was instructed that if they believed that Mr. Arnold's actions were or constituted self-defense, then his actions were justifiable. And they were told that in relation to the second-degree murder charge and the felon in possession charge. Now, they obviously felt that his actions constituted self-defense and were justified in protecting himself and in protecting his son because they acquitted him of the second-degree murder. So I guess it seems, at least in my opinion, a little illogical to say that if they thought that his actions constituted self-defense and were justified in using, I guess, force to be able to protect him and his son, then how can they not equally come back and say that the temporary possession of a gun that would be needed to, in effect, necessitate or in effect be able to carry out that protection of him and his son would not be self-defense and be lawful. It just doesn't seem to, one and one just doesn't seem to add up to two. So I believe that based on their questions that they weren't really sure about how all this was supposed to play it out, which is why we ended up with the acquittal on the second-degree murder, but we ended up with conviction on the felon in possession charge and then on the 2 subsequent felony firearm charges. Had they been perhaps instructed properly or not confused, I do believe that there would have been acquittal across the board on those, just for the mere fact that I believe there is enough on the record to support that they did believe that his actions did constitute a self-defense and they were justifiable under the particular circumstances, despite the fact that he was a felon. As far as compromise, I mean, I know there's a lot harder of a bar to kind of meet that, but I do just want to point out to the court that they were hung and they did let the judge know that, and then he essentially told them that they had to go back in there and keep going. So essentially, they were told the only way out of this juror room is if they came to a decision. So I think at some point, it is reasonable to assume that even though they really didn't have a clear understanding, that at some point they did come to a compromise, despite their confusion on how they were going to render these verdicts so that they could ultimately, kind of close it out and be let go. So that is my argument. Unless the panel has any questions, I will reserve the rest of my
Questions,
time.
judges? No. Thank you very much, Ms. Nunn.
Thank you.
Good morning, Counselor.
Morning, for the people, Madison Leonard. Unless the court has any questions regarding the points that the people have conceded, I can address specifically what fellow counsel just argued. So truly, the argument that is being made is that because there was a what seems like an inconsistent verdict when it comes to the second-degree murder count and the felony firearm count. Therefore, there must have been some level of compromise on all counts, which I do not believe that defense counsel has supported with anything beyond speculation.
Well, when you're getting into this kind of, shall we say, search for an answer, it's all speculative.
That's fair, Your Honor. I would just like to highlight the questions that the jury did ask, as that is something that that defense in their argument has highlighted as something that they point to as a bit of evidence of confusion as to all counts. Specifically, when we talk about the conviction on the felon in possession count, I would argue that the questions that were asked did not indicate that there was any confusion regarding the jury's role in determining guilt or innocence on that ground. So if I may, the questions that were asked, there were 3 that the jury asked. The first question that they asked was regarding whether or not, or which felony firearm was associated with which predicate felony. So there was 4 counts. Count 3 and count 4 were felony firearm, but there wasn't anything in the instructions that indicated this felony firearm is predicated on this, on the second-degree murder. This one is predicated on the FIP. So that was the first question that was asked. The trial court answered that question. Count 3 felony firearm is with respect to count 1, second-degree murder, and count 4 felony firearm is with respect to count 2, felon in possession. The second question that was asked requested additional information regarding what circumstances were necessary to reduce second-degree murder to a lesser crime. So while the jury is clearly having some kind of concerns during their deliberations about the second-degree murder count and whether the people had met their burden on that count, that question had nothing to do with whether or not they were satisfied with the proofs as it relates to the felon in possession count. Then the third and final question that was asked was, in which situation could defendant be charged with count 3 if they were found not guilty of charge 1? So count 3 would have been the felony firearm associated with count 1, which was the second-degree murder count. So none of those second questions obviously indicate that the jury was having some concerns about whether or not they could convict on both the felony firearm associated with the second-degree murder when they did not believe that the people had met their burden when it comes to second-degree murder, or they agreed with defense counsel's theory of self-defense. That does not indicate that the jury had any confusion as it relates to the felony firearm that was associated with the felon in possession. They were properly instructed that if they believed that the defendant acted in self-defense when he possessed a firearm, which I would note that the possession of a firearm goes beyond just the moments of the second-degree murder, but any moment during that day when he was in possession of a firearm as a prohibited person. The jury was properly instructed that the defense had brought a self-defense theory, and they clearly did not agree that self-defense was an issue when it comes to the felon in possession. And they chose to, and I mean, I would say also that the record suggests that they weren't confused at all and that they convicted on both felon in possession and the associated felony firearm. So I would argue that the defense counsel has not met their burden in establishing that that count or that conviction, the conviction for FIP, or the associated felony firearm was the result of any kind of compromise or jury confusion. Therefore, on that note, or on that specific argument, I would ask the court to reject defense's argument and affirm the felon in
You
possession.
mean the people's argument?
I apologize. Yes,
You
the
keep
people.
saying the defense. I'm like,
Oh,
wait.
I'm sorry. Sorry about that. Our argument, the people's argument, reject defense's argument and accept the people's argument, and
Gotcha.
and yes, and not vacate and affirm the felon in possession and the felony firearm count. Do any of you have any additional questions for me regarding that? Okay.
I
Thank you.
don't. Thank you very much. Thank you for coming. Appreciate it.
Briefly, I just want to address a few points that sister counsel made.
How's the prejudice on the felony firearm conviction predicated on felon possession? Rejected the defense, felon possession, self-defense.
Well, that's essentially our argument, is that I don't think that we can know that they necessarily, I mean, I know they didn't acquit on that one, but I don't know if that necessarily means they rejected trial counsel self-defense strategy. I mean, part of the
Necessarily concluded that the possession of a firearm wasn't
well, I mean, that was the result of the verdict, but under the law, self-defense isn't available to affirmative defense of felon in possession and charged when the felon is in temporary possession of a firearm. And they are able to do that in an attempt to repel an imminent threat. So it would seem that it would make sense for Mr. Arnold to be able to, retain temporary possession of a gun in order to repel that imminent. Well, my argument is, I guess that's kind of where I'm getting at. It just seems illogical that a jury would believe that a person's actions as it relates to second-degree murder were lawful self-defense actions that justify, the action of being able to defend themselves using a gun. But how at the same time turn around and say that in the same breath that person's action of temporarily possessing a gun, which is the very thing that they're using to be able to protect themselves from that imminent threat temporarily, is not lawful self-defense. And to Sister Counsel's point, there was no evidence on the record that suggested that at any other time outside of this incident occurring, the shooting, that he was in possession, of the gun. It wasn't as if, there were statements made that, 2 days ago or weeks ago, that this was a gun that he did temporarily possess it. And we're not discounting that, but that temporary possession is tied into his need to be able to have a justifiable, way to do the self-defense that he needed to in that moment.
We're looking at the prejudice of the self. That they made that same argument with respect to the felon in possession. That's, we can. do
No, I
that.
mean, point taken. That is, that is our, position on that. And that kind of goes back more into, I believe that it is our position. That I believe that they, as it relates to that, even though they didn't specifically, when they were, positing the questions to, the court, maybe they didn't specifically reference the second degree. I mean, didn't specifically reference the felon in possession count when they were doing their questioning, but I don't think that necessarily negates or means that they too still weren't confused on that. And that's our basis of that, is I think they were confused on all of it. And then ultimately they, made the decision that they made on that one. But I don't think that it's because they rejected the self-defense, to your point, but point taken, Judge. Also, just really briefly, even though Sister Counsel didn't touch on this, obviously, typically if this court, vacates someone's convictions, the appropriate remedy obviously is normally a no trial. However, there is U.S. Supreme Court precedent that does stand for the fact that it's under a very specific circumstance. So I'm not at all pushing this argument out to say that this would be the remedy in every case, but under very specific circumstances, when you have an inconsistent verdict type of situation, which is what we have here, if that trial error could resolve the apparent inconsistency in the jury verdict, then there's, as the Supreme Court put it in their case, U.S. Supreme Court, Bravo versus Fernandez, that a retrial is not tolerable. And the reason for that is because the whole reason for having a new trial generally is because we don't know what a jury would have concluded had there been no error. I think in this case, based on the error that we're alleging that occurred, and this is actually specifically to the felon in the firearm predicated on the second degree murder. I also want to make that clear. I think that had they been properly instructed in this case as it relates to that charge, I do think we can reasonably say what the outcome would have been as it relates to that count. I don't think they would have convicted him of the felony firearm attached to the second degree murder had they been properly instructed. Just wanted to make that clear because, again, a new trial here on that count, if we essentially, I think, know what the outcome would be, does not seem like that would be necessary. But again, I know the ultimate decision is up to this panel, but I did want to just kind of, put that before you all, that there are circumstances that our Supreme Court has found that, again, very limited circumstances, and typically when dealing with an inconsistent verdict, that if that trial error can resolve the inconsistent verdict, that it's not always necessary to have a new trial, if it can just be vacated. Thank you.
Thank you very much. The matter will be submitted. Item number 17, case number 373-486, People v. Murphy. Again, both sides endorsed for oral argument in this matter as well. You want to step up to the mic, please,
Yes,
sir?
Your Honor.
Thank you.
I would like to reserve 5 minutes in reply.
All right, sir.
Good morning. I will make 3 simple submissions this morning. Firstly, notice of arraignment by mail to a known homeless person is a violation of the due process clause.
What about handing her a summons and complaint?
If you handed her a summons and
Well, they
complaint?
did. I don't think that's at issue, is it? And
Yes.
your client threw it away
Well,
at the police station.
2 points in that regard, Your Honor. Firstly, the citation did not have the date and time of the arraignment that the police.
But due process is about notice and an opportunity to be heard, correct?
Those are the 2 requirements, yes.
So when you receive a summons and complaint, is that not the state's way of putting you on notice that there is a complaint pending against you? And at some point, don't you as a citizen have an obligation to take care of that complaint?
No,
You
because.
don't? You can just,
No, because the state is supposed to provide you time and date of the hearing so you can invoke your due process
which they
requisite.
did. But
No, they
s-
didn't. Not
hang
on the
Let me
citation.
finish. They sent it to her last known address, correct? Your client never thereafter, if she knew that that address was good, had she kept the summons and complaint and saw that the address wasn't good, she could have checked in, right?
Well, no,
No, she couldn't have checked in with the court?
she did not know of the citations that were mailed by the 48th District Court because they were sent to an address that she did not live at.
But somehow the police got that address, correct? Who'd
Correct.
they get the address from?
I don't know.
Oh, okay.
I
So they
presume-
might have just made it up?
No,
Is
that's
that
not
what
what I'm
you're
saying.
saying?
That's not the logical consequence of my submission. My submission is that
So
she
your
was,
submission is police ever there's a homeless person, they have to go out and physically find them and serve them
no,
again.
no, that's
No?
not my submission, Your Honor.
What is it then?
My submission, Your Honor, as set forth in my written submissions, is that the police, in this case, could have written down the notice of arraignment on the citation because they knew of it. And that would have been,
That's disputed though.
no, that is not disputed, Your
Yeah,
Honor.
actually it is because the person, I read the testimony of the clerk who you quote as saying this always happens on, I think it's a Wednesday. And that isn't what he said. What he said is it typically happens, but he also said that they would have to get a hold of the attorney to make certain that they had cases on that particular day because this was initially written as a local ordinance.
Right. I would disagree with Your Honor's conclusions for two reasons. Firstly, as I set forth in my reply brief, Sergeant Ed Ryan of the Bloomfield Township Police admitted at trial that he knew Miss Murphy was homeless on December 31st, 2023, when the citation was issued. And I don't believe Patrick Dunn, the chief clerk for the 48th District Court, ever testified that the police did not know that arraignments for the citations were held every Wednesday morning in the 48th District
That's
Court.
not what I said. What I said was he was equivocal about whether they could have set it up at that point. That's a distinction in your argument. You didn't provide for that equivocation is what I'm suggesting.
Well,
But even if that's true, again, you're asking this court to set a separate set of rules for anyone, I suspect, not only that's homeless, but may have moved, right? In the time between getting a summons and citation and throwing it away. And and the date in which the day is set. So are we to then expend our limited police resources to go out and serve people who have already been served with the summons and complaint and say, well, now we have a date?
No, Your Honor, I'm simply asking this court to follow the U.S. Supreme Court precedent regarding notice under the Due Process Clause. And there is a reasonable and practical alternative that existed here based on the evidence of Ed Ryan, the sergeant, and Patrick Dunn, the chief clerk for the 40th District Court, was that you could write the date and time of notice of arraignment on the citation and handed it to Miss Murphy. That would be actual notice. And in fact, the state, you would think, would want to embrace that actual notice, especially today when police wear body cams. You would then therefore have a real time actual notice to a homeless person that this is the arraignment date and time for them to appear. There's nothing that's being asked by Miss Murphy of this court other than whether the U.S. Supreme Court has mandated in terms of notice to a person so they receive it and can respond. What is key under the Due Process Clause and the U.S. Supreme Court jurisprudence
Well,
is
let
that
me stop you there. You're repeating, but so your complaint isn't that she didn't commit the act. Your complaint is that she wasn't served properly with a date, correct?
date and time for the arraignment, correct?
And was she convicted of anything relating to not showing up for the arraignment?
Yes, she was arrested on the bench warrants, which I would submit are void ab initio based on the violation of the Due Process Clause. And when she resisted those void bench warrants, she resisted arrest and she refused to be fingerprinted. So that's the prejudice that she suffered as a result of the fundamental violation of the due process clause.
Okay, I understood that to be your argument, but she wasn't charged separately is my point with failing to appear, correct? She wasn't.
No, she was not charged separately for failing to appear. She resisted arrest based on the bench warrants, which were for failure to appear based on the lack of notice under the due process
And your
clause.
contention is that because it was an illegal arrest, she had the legal right to kick an officer in the groin,
She had the right to resist, that's right. And
including assaulting somebody.
the fact of those consequences does not absolve the state of following the Constitution. The Constitution is the supreme law
What if
of the
she had
land.
shot him?
Was shot,
What if she had shot one of the officers and killed him?
well, that didn't happen here.
But what
And-
if it did? I mean, how far does this, you're seeming to suggest that once the state makes an error, the individual defendant can do whatever they please.
Well, I think we need to look at it from the perspective of the Constitution and what it mandates. This is a fundamental right under the due process clause. You violate that right, then the
But she,
consequence.
you know, this is where we part company. She was told she was being charged and she was given a summons and complaint, which she threw away. And so your complaint is they should have tracked her down somehow, some way, or they should have immediately given her a date because some court administrator who has no knowledge of police, how police operate, said that, well, I think they could have done it, maybe.
No, I think Your Honor is
I mean, I don't
I'm
think-
making a mountain out of a molehill, if I may suggest that, because here it's very straightforward. The
I think
due-
so too, but
Right.
in the opposite direction.
because we both agree that she was issued a citation, summons and complaint, as Your Honor calls it. When she was issued that, the police knew she was homeless. That is the testimony of Sergeant Ed Ryan, which I incorporated in my reply brief in response to the government's response brief. Therefore, mailing notice at that point in time would not have reached Ms. Murphy. If notice is to have any effect under the Constitution, the Supreme Court teaches us that it must be able to reach the person so they can invoke, as Your Honor mentioned at the beginning of the submissions here, the right to appear and answer. And that didn't happen here. So all they had to do was write down the date and time of the arraignment on the notice. As Your Honor mentioned, she threw it in the trash. That doesn't absolve the state of its constitutional mandate in the first place of writing down the date and time of the arraignment. Flowers from the U.S. Supreme Court says that. So now we have actual notice given to Miss Murphy by the police at the police station in Bloomfield Township. If she turns around and fails to appear, then she's the author of her own misfortune. But that's not what happened here. What happened here is that the due process clause was never complied with at the beginning. And therefore, everything that flows from that is a violation of that clause and therefore cannot stand. And therefore, her convictions need to be set aside.
Any questions? No. Any questions? Let's hear from Brother Counsel and give you plenty of time to respond. Good morning.
Morning, Your Honors. Brandon Barlick on behalf of the people as appellee. I primarily rest, I know the court has fully reviewed the facts, reviewed my brief. I agree with Your Honor as well, that the people, particularly the police in this case, provided adequate due process when they provided Miss Murphy a summons and she affirmatively threw that away in the trash.
What
And-
duty is on the defendant? Brother Counsel argues, and I think he makes a good argument, that it's your responsibility. If you knew that this person was homeless, first of all, why would you send it to an address you know she doesn't live at? And secondly, according to some court person, this particular, I think it's Bloomfield,
Bloomfield, yes.
Bloomfield Hills, does their arraignments, I think it's on Wednesdays or two, whatever day it was. And the police all know that, and they
Yeah.
should have just written that down. So what are your responses?
I don't disagree with that, Your Honor. I actually, in preparing the brief, I thought there would be actually additional case law somewhere out there that, talks about this issue. I was surprised to see it was not. The only framework of due process that I could find in terms of other, criminal cases like arraignments or delays between the arrest and the arraignment, that the defendant would have to show some prejudice, and I cite that in my brief as well.
Well,
but-
brother counsel says she did have prejudice because she was unlawfully arrested and therefore she had the right to resist. I think the scope of the resistance is a little off, but let's assume that he's correct in all of his assertions, which are not far-fetched by any stretch of the imagination.
Oh, and I don't disagree, and I think that's kind of, it's sort of a complicated issue. I think in primary, in terms of the arrest, which was issue number 2 in counsel's brief, the officer could reasonably rely on the lien information in the prior arrest. They don't have to do, another further investigation to talk about the validity of what's in the lien on the warrants. So I submit to you that the arrest from the officers when Miss Murphy was in the middle of the road, they needed to get her out of the road, was lawful. Then on the issue of notice in and of itself, I agree. It's if the public, if the police, if the courts know that an individual may not have an address, I can foresee an issue in which that could be problematic. The issue in this case, and I put in my brief, in this case, process was complied with when she was apprised of the charges against her and affirmatively threw out the citation. But unfortunately, there's not, at least from my perspective, there was not a lot of case law out there, dealing with a lot of this issue.
Well, what would happen, and for those of us who drive maybe a little excessively over the speed limit, from time to time, we get invited to contact the court, but there's no date. It just says you must contact the court within, I don't know, what is it, Matt, 14 days? You ought to, I'm joking.
I think it's.
Not to,
I actually think it might be 14 or 21. I think
Right,
so.
but it says you have
around there.
14 days and.
Yeah.
And that's kind of where I went with this and I
Yes.
thought, well, so I do have some obligation.
Yes. Yes. And, now that the law has changed on many, because Your Honor was correct, this was initially charged as a city ordinance. And on many of those appearance tickets, I know from practice, right, they'll include a provision at the bottom that says that you're responsible for contacting the court, right? You have to make some affirmative obligation. And, problem with this record, and I will concede, is it wasn't clear. All this prosecutor needed to do was get a copy of what was, issued, submitted into evidence as sort of demonstrative evidence, and why that wasn't done in this case, I can't speak to that. So I think that could have cleared up a lot of the issues. But yes, the onus would be on the individual getting the ticket that you need to, affirmatively request from the court.
What is your response specifically? And I apologize because I interrupted you while you were answering this, so give you another opportunity.
Sure.
But brother counsel's argument is that because the arresting officer, because the issuing officers failed to adequately provide notice to his client about the time and date for the arraignment, that negates the lawfulness of the arrest or the validity of the arrest.
Yeah, I don't believe that that's the case. Because in reviewing the case law, the due process requires a defendant to be adequately apprised of the charges against them, not necessarily the official date and time of the arraignments. That's Darden that I cited in my brief, as well as In re Messner in my brief as well. And counsel discusses flowers. I would note to the court that involved a tax sale on property, which is a little bit different. And so that would be my response, Your Honor.
Yeah, there doesn't seem to be any case law revolving around due process in this
Context.
Right.
Right,
It's all about, did you adequately provide me notice of the charges?
correct.
So it's an interesting question.
It is. But again, I think I would go back to, the heart of this. Miss Murphy was apprised of her criminal conduct in the form of a summons, which she affirmatively threw away. I could see an instance in which she was placed under arrest, wasn't given any paperwork. The officers knew there, went along her merry way, and all of a sudden there's a, criminal charge against her, a warrant is issued. I would submit that that would be a different case. But in this case, she made an affirmative act in which she threw out the complaint.
Well, counsel also, although he didn't give him an opportunity to say so in an oral argument, he also contends that the police had other encounters with the defendant and did not arrest her
Yes.
at that juncture.
Yes.
Does that change the analysis in here?
No, because I think the police, have wide latitude and discretion whether to arrest. And I think, as the record indicated at trial, the Bloomfield Township Police, tried to provide services for Miss Murphy. And I think went out of her way to, try to help her. And I think in those instances, they lawfully exercise their discretion to not arrest. That doesn't negate the fact that, there was something on the books within Lee to make something arrestable. But no, I don't think that changes the analysis.
Any questions of Tom? Thank you very much. I
Thank you, Your Honor.
appreciate your
Thank you.
candor. Rebuttal, sir.
The Supreme Court has provided this court with guidance, and let me amend that, the U.S. Supreme Court. When you're looking at an issue of deprivation of liberty, now the cases that I cited in my brief and the government also responded to in its brief, and now all deal with deprivation of property and the applicability of constructive notice in those cases, which doesn't apply here. Here we're dealing with a deprivation of liberty. The Supreme Court has set out the test. It's been the test since Mullane back in 1950. That's been affirmed up to date, which is essentially what is reasonable under all the circumstances of the case in order to provide notice so the person can, as Your Honor noted earlier, appear and answer to the charge. And here, that notice was not provided to a known homeless person, because when you mailed out that notice of arraignment, they knew she would have never received it because it went to a mailing address and she didn't have a mailing address. And here, there was a reasonable, practical alternative. Write down on the citation the date and time of the arraignment. And in Your Honor, questioning the government's lawyer this morning spoke about 14, 21-day notices. You're invited down to the police station. Well, on all those notices, you have the address of the court, you have a phone number for the court. You can do all that and find out what's going on. And they give you a date, 14 or 21 days, as government counsel admitted this morning in his oral submissions. We don't have any of that in this case. So how could the government say that it provided due process as mandated by the U.S. Supreme Court in this particular case? And it didn't, because we know on the facts it didn't receive Miss Murphy and bench warrants were issued for her arrest. Here, a reasonable, practical alternative existed. Writing down the date and time of the notice of arraignment on those citations. If that occurred, we wouldn't be here. And
I
the
think
fact,
I understand the argument. Let me ask you briefly about the arrest. I'm going to assume that for purposes of this argument, that you are correct, that it was an invalid arrest because you. How far, what is the scope of her ability to resist under our case? Does it include assault? Is it any means necessary?
should it be qualified, but it's reasonable under the circumstances? I don't know, because now what we're doing is we're saying the Constitution mandates this test under the due process clause. The state has to follow that test. If the state doesn't follow that test, what is the right of the citizen to not comply with the state's failure to follow the constitutional mandate? And I haven't found any case law on this point.
Nor have I. That's
Yeah,
why
and
I'm
as
asking.
Brother Counsel noted also, I guess it becomes a question of what's reasonable under the circumstances. And I don't think it's unreasonable in this situation for Miss Murphy to have responded the way she did in terms of a violation of the due process. Going back to your Honor's hypothetical at the beginning this morning, if you pulled out a weapon and shot the police officer, that might not be considered reasonable in terms of the scope of the response to the violation of a fundamental right under the Constitution. Those are my submissions, Your Honor.
Excellent submissions they are. Thank you very much. I appreciate it. You've done one whale of a job on behalf of your client. You truly have, and I thank you sincerely for that. The matter will be submitted. Thank you both. Excellent submissions, interesting argument. One we're gonna have to think about for sure. Thank you, you too. Item number 18, case number 374501, Brown versus All-Star Insurance Company. It shocks me to learn that we have an action against an insurance company. Never happens. Good morning, gentlemen.
Couple questions for you first. How much time do I get? Is it 15 or 30 minutes?
Well, I wouldn't tell you that, because if I tell you, then you'll use it all.
Not
It's
necessarily.
2.
Two?
Ask the lawyers behind you how much time you get. Actually, if you're so single, double endorsed as you are, it is 30 minutes.
I just want to make sure. I would like to reserve,
28?
no. Well, you
Following my
either get it
point?
up front or at the end. So, 5 minutes, for rebuttal.
No problem. Thank you.
Thank you. May it please the court, Brian Courier, appearing on behalf of the plaintiff slash appellant. And, just as a matter of curiosity, what kind of car do you drive?
He's
was
not
brought up
gonna
in the
answer
beginning.
that, but he drives a nice car,
Okay.
a very nice car.
I'll submit everything.
But not as nice as mine, and certainly not as nice as Judge Kelly's.
Thank you. I think it's important to go over a couple things in this particular case, which deals, as the court knows, with our claim that there was an abuse of discretion when the trial court granted defendant's motion to dismiss. It's helpful, I think, to begin with a timeline of what actually happened. The complaint in this matter was filed on June 15, 2023. On January 22nd, 2024, which is the most significant date of all these, there was a stipulated order compelling the plaintiff to provide supplemental initial disclosures, executed authorizations, interrogatories, and requests to produce responses, as well as submit to his deposition. On May 6th, there was a motion to dismiss filed by defendant. A notice of hearing on that same day, May 6th, was set the matter for hearing on May 31st, 2024. 3 days later, there was a re-notice of hearing sent by defendant, setting it for 2 weeks earlier for May 17th. On May 13th, plaintiff contacted defense and said, "What authorizations do you need?" Those were provided to them, and 2 days later, those were executed and sent back. On May 14th, plaintiff's attorney called defense attorney Hannah Polly, and I apologize if I mispronounced the last name, called her to talk about resolving the issues before the hearing. On the 16th of May, plaintiff sent an email to the defendant indicating his belief the hearing was scheduled for May 31st, 2024. He had looked at the first notice of hearing, which again did indicate the hearing was going to be May 31st. On May 17th, the hearing was held, And to no one's surprise, plaintiff didn't file a response to the motion. They didn't appear to the motion. And an attorney for defendant, because they thought it was the 31st,
because
because it was initially noticed up the 31st, and then there was a renotice for the 17th. And when he looked in the file to see, verify when it was, he didn't see the 17th. It was a mistake on his part.
so we excuse, what date, what was the date of the filing of the complaint?
The complaint was filed June 15, 2023.
Now we're talking about a year later, almost,
Just about,
right?
yes.
And still the defense doesn't have what they've asked.
That's not
And
true.
plaintiff didn't show up for a hearing.
That's not entirely accurate.
What's inaccurate about the date of the filing, the date of the hearing, and plaintiff not showing up?
All of those are correct.
Okay,
What was
how
not,
long should the court have given your client to answer these interrogatories,
well,
in your opinion?
we know how long the court should give them because it was in the stipulated order. Now, the supplemental initial disclosures,
Hang on.
Yes.
Did your client comply with the supplemental order?
I was going to go over there were 4 parts to the order. And I was going to
It's a
go
pretty simple question, though. Did he comply
with which part?
with any of it?
Yes.
What part did he comply with?
The 4 parts of it that he complied with were executed authorizations. Those were due January 26, 2024. Those were executed and sent on January 25th, 2024, a day before they were due. There were interrogatory and request to produce responses due, according to the stipulated order, February 9, 2024. Those were also sent to defendant on February 8, 2024, one day before the last day. Plaintiff's deposition, according to the stipulated order, was to take place on or before March 4, 2024. His deposition took place on almost a month earlier, on February 8, 2024. So of the 4 parts of the
What
order,
was the fourth part that you missed?
the 4th part was the supplemental initial disclosures.
You didn't file those because,
Those were not filed in large part because it was our belief that the information sought, as set forth in their brief, was they wanted bills for 4 different providers. Now, since the time of that stipulated order, they were provided avenues for that information. Number 1, the executed authorizations provided them with the ability to get not only the bills, but the medical records and the bills to find out how much was being claimed. There were interrogatories and requests to produce that were also provided, as well as plaintiff's deposition.
so you're now telling us that you did comply. That's your argument.
Well,
You
I'm gonna-
partially
I'm
complied.
going to couch it this way. We believe we complied by providing the information they sought. We didn't do it in the form of a separate document that said supplemental initial disclosures, but the information sought was provided, yes.
Well, I haven't done discovery in 25 years, but don't you have an obligation to respond in kind to the request at some level? Or can you just start sending records willy-nilly? Is that how we do discovery these days? I'm asking because I honestly don't know.
Well, discovery is usually conducted with respect to the authorizations. Oftentimes in the initial disclosures, it'll identify providers that they've seen. Discovery responses, interrogatory answers will identify what providers were seen. A deposition will reveal what providers, treaters they saw. And once they get that information, authorizations for release of the records from those providers are given to.
How many times did the insurance company have to motion the court to get your client to produce information?
It's my understanding and belief there was one motion that we agreed to through the stipulated order to provide the requested documents. So-
one before this one, correct?
There was a motion filed before the stipulated order was entered.
So there were two motions total filed for defense seeking to compel disclosure. The first one resulted in a stipulated order, and then there's this one.
Well, the first one was a motion to compel discovery. The second one was a motion to dismiss for failure essentially to comply with the stipulated order.
Huh?
Now, at the time,
How many motions does a party have to file before the court has an obligation to dismiss the action for failure of prosecution?
I think a better question is, why would you file a motion to compel discovery that's already been produced? And that's what we have here.
The court didn't see it that way.
No, it didn't.
Tell me why it was wrong then. Because it seems to me that if you have a defense here, your defense is I complied, and yet the court still dismissed my case.
Right. And why
Because your
did that
client
happen?
was anything but forthcoming. I mean, let's just be brutally frank here. And I think what's troubling to a trial court and to this court is it's your client's case. He's the one who brought it. So when you bring an action, you have an obligation to respond, assuming arguendo that the requested information is within the confines of what's discoverable, to respond to that. And clearly your client at a minimal had problems adhering to that.
Well, at the time, keep in mind, at the time of the motion to dismiss, the order had been complied with on 3 of the 4 parts for upwards of 3 months before the hearing on this motion.
They say the interrogatory answers were insufficient.
Okay,
I
right.
mean, right, so I mean, you could say I complied, but if the answers were all nonsense, then that's really not complying. Do you
Well-
think they were sufficient?
I think the best way for me to address that is that was something that was brought up at the motion to dismiss hearing. There was never contact with us when we provided them back on February 8th. Nothing from them saying, hey, we need better answers. Instead, they lied in wait, filed this motion and appeared without us being there and said,
But wait a
The
minute,
answers we
when you
got-
say without us being there, you just misread the file.
Right.
So let's not try to use that as an excuse.
oh, we weren't there.
I know you weren't there, but you weren't there because your associate didn't read the file right. He thought it was
100%.
the proper date was given
Yes,
and you guys blew it.
yes,
Okay.
100%.
So I mean, when you say, and we weren't there, you're suggesting that they took advantage of you,
What I
like the
meant,
last case.
what I meant to suggest is because no one was there, there was no opportunity to explain to the judge that their complaint with our answers to the discovery was a newly raised issue that hadn't been brought up to us before.
Do you think they were sufficient in looking back at the answer?
I don't know what the deficiencies are, other than just a general claim they were insufficient. There's no specificity as to what was
Okay.
in error with them, what they didn't like about them. And that's why I said they never brought it to our attention beforehand.
Sure.
Had they, we would have had an opportunity to go, oh, we disagree. We think they're sufficient, or we could say, okay, here's some supplemental answers. But we were never afforded that opportunity before the hearing. And again, they had those since February 8th. Now, addressing the issue of the court and its decision. I'm not faulting the trial court judge per se for his ruling. And I know I have an uphill battle here trying to convince at least 2 of you that there was an abuse of discretion. The trial court judge, the information he had was, I believe, insufficient for him to make the ruling that he did, which was in fact to dismiss the plaintiff's entire claim. And I say that for a couple reasons. Number one, when the hearing took place and throughout the transcript of that hearing, you hear the judge at least 3 times saying, I can't believe plaintiff's counsel isn't here. Why aren't they here? Where is he? Now, when the court asks that question, the attorney for defense was there and heard the court ask, where is he? That attorney knew why we weren't there, because we had sent an email saying,
You know what? That's one of the most absurd arguments I've ever heard. There is no way that you're gonna blame this on your opposing counsel for your inability to appear. Let's not even debase. That's a ridiculous argument. The court considered, when you're trying to decide whether or not you should dismiss a case for insufficient or violations of discovery rules, we go through the Dean factors. In my opinion, at this juncture, I believe the court went through the Dean factors.
it did.
I assume that you don't think so, or what factors would you point to lead us to believe that the court got that wrong?
No, it clearly went through the Dean factors. The issue I have with it is when it went through the Dean factors, it didn't have all the information it should have had. That's my main argument
And it didn't have the information because you didn't show up at the hearing.
for a couple
right?
reasons. That's one reason.
Okay.
Yep.
So,
The other reason is defense counsel who was there misled the court by telling them with respect to the authorizations, there was a discussion about it, brought up by defense counsel. We just got authorizations yesterday, day before the hearing. Well, what defense didn't tell the court is the authorizations that were subject to the January 22nd, 2024 order. It said you have, by the certain date I just gave you, to execute those outstanding authorizations. Now, we did that within 2 days, or a day before they were actually due. After that, there were new authorizations sent that got signed as late as the day before. Those authorizations were not part of the January 22nd, 2024 order. Those were new ones that they sent after the discovery responses and after the deposition. They weren't part of the January 22, 2024 order. The defense attorney made it appear to the court that those outstanding authorizations of the January 22, 2024 order, that those came in the day before. And that's simply not true. Those were all provided timely under the court order. So the judge did go over the Dean factors, but my contention is with the lack of information and the misinformation it had, it made a mistake. Now,
abused its discretion, not just made a mistake. It
Yes.
abused its discretion.
Of
So
course.
was it a mistake of law? Was it a mistake of fact? Was it a combination?
mistake of fact, I believe,
Which led to a mistake of law, correct?
by its ruling, yes.
Is there one Dean factor in particular that you,
Have an issue with?
probably eight,
Um,
that a lesser sanction would have better served the interests of justice?
I got several of them. The first factor, whether the violation was willful or accidental. The court pretty much said that this was willful. Now, the violation, again, we're focusing on the January 22, 2024 order. 3 of the 4 parts were timely complied with. The only thing that wasn't was, like I said, the supplemental initial disclosures, which they claimed we needed information, the bills of 4 providers. That was provided to them through authorizations that we gave, through the deposition testimony. They had either the information or access to the information. So I think when the court said this was willful, one of the 4 issues was willful. When they had the information that they're claiming they needed, they had it. They didn't, like I said, they didn't have it in the form of a document called supplemental initial disclosures, but they had the information they were seeking. The second factor, the party's history of refusing to comply with previous court orders. Again,
So
Yep.
Judge Kelly's question was, is there a factor? And your contention is it's all of them? Is that going to be your response rather than going through each and every one of them? Is your response, it's all of them?
I have issues with how the court came down on all of them based on the limited information it had. And even with the information it had, I think it made mistakes in its ruling with information, sufficient information that it had. And I also think there was a factor that it simply skipped over, which was factor number 2, the party's history of refusing to comply with previous court orders. The trial court didn't make a finding as to that factor. Instead, they moved on to factor 3. Now, I'm going to point out to the court, we're talking about one previous stipulated court order. There was no other court orders that were arguably violated. I don't think that
Is there a case that says that violating just one court order is insufficient to dismiss?
I believe there is, and I don't have that with me, but my understanding
Okay.
is there is.
Is it in your brief? Do you
Um,
remember? Because I don't remember seeing one.
Yeah, I don't think it was in there.
Okay.
But again, the court skipped over that factor. The third factor, prejudice to the opposing
All
party.
right, we get it. I'm gonna cut you off here unless you have any other questions, Judge Ackerman. I'm gonna we want to hear from opposing counsel. You'll still have your time. We'll give you ample opportunity to respond.
Okay, thank you.
All right?
Appreciate it.
We don't need you to read your brief. We've read it, obviously. Go ahead, counsel.
Let me
Thank you,
start
Your
off
Honors.
with, on this 8, I mean, is it, why wouldn't a lesser sanction under these, I've seen them where they violated 15 orders and a judge still lets it go on. It is discretion, but here there's not a lot. Why wouldn't a lesser sanction would better serve the interests of justice? To say, listen, this is your last crack at it. If you don't get this, it's all over. Here's your final warning.
I think the judge made a sufficient finding that the ongoing, this is not just one of a violation of a court order that was agreed upon in January. What happened was there were continuing obligations to supplement. There were additional, one factor that didn't come up in the prior discussion is when the claimant's deposition, when the plaintiff's deposition was taken, there was a promise made on the record during the deposition that various documents were going to be provided regarding replacement services and wage loss claims. Those documents were never provided. And it was actually, I took the dep. I was very specific. We had a 7-day agreement on the record, with a court reporter taking that down. So what we have here is we have a number of ongoing violations, and I think that's why the dismissal was appropriate and a lesser sanction was not going to serve the interest of justice. Defense was copiously litigating this case, and I think that hopefully answered your question.
In this business about the insufficient interrogatories, what were the problem?
So it's detailed in the motion to dismiss we filed. There were a lot of nonsense boilerplate answers, but there was also deficient information regarding those items I just mentioned, replacement services, wage loss claims that were germane to the plaintiff's case. None of that was contained in the answers, and that's why we included that in our motion to dismiss.
Important stuff, as we say.
Yeah, it's a lot of important stuff. These cases are, in my view, they're labor intensive. We work our cases diligently. I do want to speak to this whole business because I know Justice Borrello, you got.
Oh, don't demote me. That would be a pay cut.
Judge Borrello, I'm going to be demoted, I'm sure. Judge Borrello, you did not like the argument about the reliance on some communication with defense counsel. I want to make it clear that, my office never made any misrepresentations. And in fact, I believe it's in our brief, there was actually a phone call to plaintiff's office on the date of this hearing to see if somebody was going to attend the hearing. There's another item
let me just explain real briefly. I made mistakes as an attorney. In fact, God knows probably more mistakes than I did things right, which is why
I just
ended
made
up
one.
on
I
the
called you the
bench.
wrong title.
Right. But you have to own your mistakes. You have to admit, I made an error, and you move on. Now, it could well have been you made the error based on somebody else's advice or but it's your error and you need to own it. And when you don't, I find that very troubling, because the thing about this profession that makes us, I think, one of the best professions in the history of professions is the ethical obligations that we as attorneys have, not just to one another, but also to the court and to our clients. And so when I sense that there's some trying to pawn that off, I get upset.
So let me say one more point along those lines. Council made a big deal about, we didn't get an opportunity because we weren't there. We didn't get but they did. They filed a motion for reconsideration. And that was denied by a different judge.
Right.
And I think that's pretty compelling. You had two judges take a look at the Dean factors. And I thought the first judge on the case, in fact, plaintiff relies on a number of cases in their brief. The Vincencio case, I believe it is a case that talks about that the judge should walk through all of the factors before coming to such a conclusion. And he did just that. They filed a motion for reconsideration, and a second judge presumably did the same thing and said, no palpable error. So they got their second bite at the apple, and it was denied, and for good reason.
So this is the third.
Yeah. So I really don't have anything else. I think unless you have more questions for me, I think I highlighted everything I needed to highlight.
Any questions for counsel? Judge Ackerman, thank you very much. Good to see you again, counsel.
Thank you.
Rebuttal, sir.
Because the issue is whether there was an abuse of discretion, it's terribly important to have the factors addressed and decided whether or not the trial court judge reviewed the facts and came to a logical and reasonable conclusion on these factors. Now,
This is
overall,
rebuttal, so I don't know that brother counsel addressed that. Do you know, Judge Kelly, did he address specifically?
I'm not quite clear what he was getting at yet.
Yeah.
I
where are we
thought
going
because
here?
you cut me off to let him in, I wasn't going to be limited to rebuttal.
Here's the thing, counsel.
Okay.
Oral argument is for our benefit, right? I'll let you go, but we've read your brief. What more do you want us to know about what's in your brief?
Well, I think I'm pointing out a few minor things that help explain what's in the brief. I didn't prepare the brief. And I think it's missing some of the details and important nuances.
No, I just have to say, you didn't show up for the hearing. You didn't prepare the brief. It seems like you got a lot of excuses, and that doesn't sit well with me. Just doesn't.
Well, I understand.
So are you telling us now that the brief is deficient? Is that your contention to this court, that the brief is not sufficient for us to read and review? What exactly is your point here?
No, I'm not claiming it's deficient. I'm just trying to offer some additional information to help the court understand what our arguments are.
All right.
One thing that wasn't brought up in the brief, though, was the court, when it dismissed it, it made a statement in the transcript, and it talked about if this were ever appealed, what should happen. And the court said on page 16 of the transcript, it said, if such a motion is filed, either yours truly or my docket successor shall consider the request for attorney fees and to strike the claims as listed as lesser sanctions in the event appellate relief causes this ruling to be undone because I'm dismissing this action with prejudice. So I'm not sure if the trial court judge can tie your hands if you were going to be granting our relief requested and setting aside the order, whether his portion of the order stating, well, if it comes back and you overrule me, I'm still gonna invoke these lesser sanctions. I don't think the trial court has the ability to do that, to tie your hands like I'm suggesting it seems to be wanting to do. So I wanted to bring that to the court's attention in the high hopes that you grant our motion. Or our-
Anything else?
No.
Any questions? Thank
I mean,
you.
It sounds like you have a tough client and nice to do your
No.
carry the law. And so there's some that you can lead a horse to water, they won't answer stuff,
No,
but,
there wasn't an issue. That,
okay, well,
judge
he
thought
certainly
that.
wasn't responding to stuff, was he? But anyway,
This
we're done,
happens.
so
it happened.
go ahead.
Thank you.
Case number 377981, item number 19, Uden versus Mukaram. We have one pro per. Good morning.
Good morning. I'm Samira Mukarram, proper as appellant defendant. And this appeal concerns whether the trial court exceeded its authority by adding a new substantive requirement mandating a specific tax preparer through a post-judgment motion to compel. The judgment of divorce required the parties to file a joint tax return. It did not require to use a particular tax preparer. By imposing this additional requirement through a motion to compel, the trial court did not enforce the judgment, but actually modified it. So a few things I wanted to kind of highlight in terms of, it's everything laid out in the brief, but the trial court introduced a new requirement which was never litigated, never decided at the trial, and not part of the judgment for a specific tax preparer. And tax preparer choosing is important because it financially changes liabilities and kind of, the deductions, what kind of deductions we would want to proceed with. And I actually went and had a licensed tax preparer prepare the taxes for the joint parties. And the liabilities were much lower and would be beneficial for both of the parties, but the plaintiff did not agree and filed a motion to compel. And this was seen as I had refused, but the main issue was the tax preparer, not the refusal. There was no refusal, no testimony about it, no evidence submitted in regards to that. And it still was presented in a way, and the court erred by, Your Honor, imposing to making an obligation, ordered me to file jointly or give an option to the plaintiff where he could file it separately if he wishes to. And in terms, if he proceeds with filing separately, then the liability would be mine. So it's kind of, a punishment in a way towards me. I was not even given an option for other possibilities that could have reduced this tax burden, which is my legal right in terms of tax preparing and what deductions I want to use and all those things. So I respectfully request for reversal of the portion of the order and vacate the attorney fees because it was no evidence and I did not refuse at that time.
Anything else you want us to know?
I think that's all I have.
That's all? Do you have any questions,
I
Judge
don't.
Kelly, Judge Ackerman? Thank you very much.
Thank you.
The last attorney should have done a job like you did. The matter is submitted. Item number 14, case number 366514, People v. Snell. Good morning, counsel. Who's gonna go?
We are not endorsed for oral argument, but we filed a motion for oral argument and we're allowed to appear for questions.
Correct.
So I don't know if the court has questions for us now or later, but
Let's hear from brother counsel, and if there are any questions, we'll let you know. How's that?
May it please the court. Good morning. Assistant Attorney General Brent Morton on behalf of Newaygo County. As a preliminary matter, I appreciate the courtesy of the court and opposing counsel in this case and the next one in moving it to the bottom of the docket. I was able to make it here timely, but you never know with the construction season the way it is. As to avoid just reciting or repeating my entire brief, there's one thing.
Oh, Mr. Morton, you're very good at doing that.
I know. I've got most of it written down here.
I figured you did.
I did notice something that I thought was worth mentioning as I went through and prepared for argument this morning. And that's under the venue argument. Mr. Snell is arguing, well, I couldn't get a fair shake in the community because the family of the victim was so well known. But yet in his standard 4 brief on page 5, he asserts that there are many parents in the school who swore to kill Rick Atwood because he sold drugs at the school. So it's sort of a conflict there. You know, was the community outraged because of what he was doing at the school? And were other people, likely suspects, and wanting to kill Mr. Atwood? Or was there not a fair shake? And I think with regard to the venue arguments, they didn't get a fair trial. That's never established. There's no information about the family and the reputation of the family and their impact on it, nor is there any information or offer of proof made regarding bias. Again, to avoid repeating things, I just would be happy to answer any questions you have.
What bothered me about this case is the ineffective assistance of counsel relative to not having a mitigation specialist lined up. Can you address the defense's claims there?
Well, I was disappointed in the way that went, the way that was handled. I was disappointed with the mitigating specialist report. I would indicate that Mr. Snell was unwilling to cooperate with the PSI interviews or with his own mitigating specialist. So I think the focus in the ineffective claim really needs to be on whether or not they've proved a reasonable likelihood of a different outcome.
But wouldn't you agree, Mr. Morton, that the mitigation specialist in a Miller hearing is pretty much all the defense has? That's not a fair assertion. It's an important part of a defense to make the defendant's case about the Miller factors.
I think it is important information for the judge to know. I did indicate and kind of outlined in my brief that the judge did know a lot of the information that they're alleging should have been in the mitigating report. His drug history, his juvenile criminal history in, I want to say Chicago, but in another community. So, I mean, our position is I don't think there's a reasonable probability of a different outcome because the court was made aware of those issues, although clearly the mitigating specialist would have shined it up and done a better job of presenting it. But
there's a difference between shining it up and completely bungling it. I mean, this had to have gone down as a real horrible thing when this expert just didn't know the first thing about it. I mean, the whole thing sort of takes on a taint of, I don't know, incompetence with it. It's bothersome to see what happened there, I think.
My disappointment was that there wasn't a request for an adjournment so that some more time could be given to the mitigating specialist. But I do think that also reflects upon the lack of cooperation Mr. Snell gave that specialist and unwillingness to cooperate with
Yeah,
him.
but I mean, the wrong person showing with the sister of the owner of the company and, I mean, it's just bad luck all around.
I can't defend how that was handled.
Yeah.
But I think the focus should be on the other Strickland or the other factor.
Any other questions for enlightened counsel? No problem moving the call, although I had to really arm twist these two because candidly, they don't like you.
I got here in Malibu. I did the best I could, so thank you so much.
I can joke with him because I know him, so everybody relax. You want to head up? I have a couple of questions for you, if you don't mind.
Can I first just address a misstatement of fact?
Can you do me a favor and state your name?
Yes, thank you. Catherine Marcus from the State Appellate Defender Office on behalf of Mr. Snell, and I'm here with co-counsel Marilena David.
Let's keep it to question, shall we?
Yes.
So, do you have a question for counsel?
At the moment, but if maybe a follow-up.
Was the lack of compliance with the PSIR or with the mitigation expert or both?
It was only the PSIR. Mr. Snell met with the mitigation specialist that counsel hired, or the colleague of the mitigation specialist that counsel hired, on the one occasion that she met with him before the Miller hearing. There was no lack of compliance there, and then Mr. Snell was very compliant with the mitigation specialist our office hired. Thank you.
Do you think that this court has sufficient information on your ineffective assistance of counsel claim to render a decision at this juncture, or is this court mandated to remand for a Ginther hearing?
Your Honor, I think the record is clear that counsel's performance was deficient with respect to the Miller hearing. The record is clear that the mitigation specialist that was called to testify was unprepared and needed more time, and had not reviewed the records, had not met with any witnesses other than Mr. Snell on one occasion, and was not prepared to speak intelligently about Mr. Snell's life.
And this little gonna take you a little off the beaten path here, but I'm curious as to your opinion of this. Is it fair for a court, reviewing court, to blame the deficiency of a witness on trial counsel? I think here it's a little easier because it was clear that trial counsel didn't really know what they were doing. And in fact, I think the record's clear, if they're not mistaken, was their first Miller hearing. But what about that? What about if a court would say, wait a second, counsel hired a mitigation specialist. She set up an appointment, or counsel set up an appointment for their client to meet with the mitigation specialist. Why is this counsel's fault and not the witness's fault?
Your Honor, it was counsel's responsibility to conduct the investigation, or make sure the investigation was conducted, and to prepare for the hearing. So going into the Miller hearing without ensuring that the investigation was complete, without talking to the expert that she was calling to testify, without actually knowing who would be testifying at that hearing, without any kind of report, that's the deficient performance. That is objectively unreasonable.
Now let's talk about the hard part, shall we? Let's talk about the prejudice problem. What would you say? Now I'm going to let you write the opinion, right? What would you say relative to a finding of ineffective assistance as to the prejudice problem?
Respectfully, I don't think prejudice is the hard part. I think that there was a Miller hearing here without any mitigation presentation, really. And the court did have some biographical information about Mr. Snell. It had some understanding of his prior criminal history, but it wasn't able to put any of that in context. It also had some misinformation. It believed that Mr. Snell's childhood was idyllic when it was nothing like that. And it also,
And I'm sorry to interrupt you, but the mitigation specialist that you retained explicitly states that, if I'm not mistaken. I just wanted to make sure that I was correct.
That's correct. The mitigation specialist that we retained authored a report that was attached to our motion to remand and to our brief, and that talks about the instability in Mr. Snell's life, lots of transients, instances of abuse and neglect, substance abuse in his family. There's a long sort of history of a much, not an idyllic childhood.
Now, because Mr. Morton needs to spend more time in Newaygo County, and we would hope that if we send it back, he would be the one to try it. If we do agree with your arguments and we send it back, would you be handling the matter on a remand, or would the court, I don't understand, or would the court have to appoint someone new? Would we have to start all over? Or how does this, can you help me with the process here? Because I confess complete ignorance.
I can, yes. If the court remanded it for a Miller hearing, our office would continue to represent Mr. Snell at that hearing.
Would it be advantageous, and let me just suggest, I think you've done an outstanding job for your client, and I think it would be in your client's best interest to have you, if we were to incline to do so, to have you do the Miller hearing. Is it permissible, I guess would be the word, for a court, for an appellate court to order that you be appointed for this, or is that unnecessary? Is that something that you at SATO would rather do internally?
I think the court could do that. I also don't think that it's necessary. We are,
It's part of your obligations, is it?
it is, yes.
I just didn't know how much trial, because this would be considered, to me at least, trial work that you folks did.
We typically, when the court remands for resentencing, we handle the resentencings in those matters. And if the court remands for a new Miller hearing, we would do that. If there's a remand for a new trial, sometimes we are sort of initially overlapping, but then obviously trial counsel is appointed.
Oh, okay. Well, obviously the only person I can ask is Judge Young, and none of us trust her, so that's
Fair
why I
enough.
had to ask you.
I have one thing that bothers me about this, and I can't quite figure it out, but the argument that imposing a life sentence without possibility of parole for a murder committed when he was 18 years old must be categorically barred as constitutionally disproportionate. But, in this case, although he committed it at 18, he went nearly 40 years without being punished for it. Okay? So, it'd be one thing if I'm 18, I commit this murder, a year or two later, I get convicted. But I mean, almost 40 years, most people that hear that would say it's time to pull out the world's smallest violin. I mean, you went the prime years of your life without serving a day for this punishment. And now in your late 50s or mid 50s, you're starting to serve a life sentence. And it just doesn't seem to fit with that, the original purpose or intent of this, which is, an 18-year-old doing life. So what do you, is there an exception for these unique circumstances?
That last argument in the brief is a law reform argument, obviously.
right.
That would apply facially,
Right.
across the board to all 18-year-olds. And I understand that the circumstances are somewhat different here because a life sentence for someone who's sentenced at 59 is different than someone who's sentenced at 18. But it focuses on the proportionality and constitutionality of sentencing a person who is whose brain is not fully developed to life without the possibility of parole, and it is a facial challenge.
But maybe
Yes.
in this case, it just doesn't quite have the
The same
punch it
heft.
does for an 18-year-old, but
Yes,
you
I
made it.
agree.
So it's just, I've been thinking about that since I've read this. So there's something that just doesn't seem to ring true with that argument for these particular facts, but you've explained it. So thank you.
Any other questions? Did an excellent job for your client, counsel, and we appreciate everything you've done.
Thanks for giving us some time.
Thank you. Matter is submitted. Mr. Morton's here because we like him so much, for yet another case. And that is item number 15, case number 367916, People v. Vert. Again, both parties are endorsed for oral argument in this matter. Good morning. How are you?
Good morning. Great. Thank you. Morning, Your Honors. My name is Ashley Siegel. I'm here for appellant Sean Vert. May it please the court.
We know who you are. But thank you for reminding us.
Thank you.
What do you want to tell us about your friend, Mr. Vert here?
Well, first of all, this case is a little bit different than the case law. I'm going to start with what I think is the strongest argument or issue in this case is that he appeared in front of the jury in corrections attire. The reason it's
Yeah, but it's almost more of a safari. I mean, if you had like a pith helmet to go with it, nobody would know that he wasn't
So-
heading out to look at lions somewhere. This isn't your typical orange jumpsuit, is it?
So now that your honor said
Okay.
that, I'm hesitant to say what I wrote down, that I think that Appelli was disingenuous in saying that it didn't appear to be corrections attire. Anybody in this courtroom or any courtroom, and certainly those 12 jurors, can tell the difference between an institutional outfit and a not in civilian clothing. This was a khaki jumpsuit. Appelli says that there was no MBOC insignia on it, but it's an institutional. Where would you buy it? Why would you buy it? Why would a civilian have this? Where would they get it?
I know in our town, and not to start an argument, but one of the ways that one of our law enforcement people thought would be a good way to raise money when they switched jumpsuits was to sell old prison garb, and they had no trouble getting rid of it.
This is a county in northern Michigan.
So is
people are not-
Saginaw.
They're not, people are not going out and buying institutional clothes and wearing them to court, you know, on an important day.
Oh, you'd
This
be
is-
surprised what we see in here.
This is especially important in Mr. Vert's case for a few reasons. One is that the video that was shown of the incident, he was in jail. So there's this compounded prejudice of he was in jail at the time of the crime. So they know he's in jail there, the alleged crime. And then also 3 years later, we see him here with an MDOC guard behind the bar behind him and across the courtroom, and him in institutional clothing. So 3 years later, this screams to the jury, this is a bad guy. He was in jail then, he's in jail now. It kind of forecloses the jury's ability to think that maybe it was just like a guy having a bad night, you know, drunk tank, whatever, kind of a one-off, could happen to anybody. It really hammers home that it's a bad guy. The other thing that's interesting about this case that distinguishes it from other cases, we have a court order signed by the judge that is very explicit. Shall be in civilian attire, and then in parentheses, shall not be in corrections attire. This is a case where the defendant claims innocence, demands a jury trial, and I think it warrants a review and compliance with the record, and that didn't happen here. So I will move on from that because I do have several issues. Another matter that I wanted to talk about a little bit is the failure of defense counsel to motion for a directed verdict. I guess this is a sufficiency of the evidence argument. Here, one of the things that Appelli says is that Mr. Vert was angry. That doesn't prove intent to destroy something. Actually, it can mitigate against it. If he was just throwing something to blow off steam, that is not intent to damage property.
There's a video of him just winding up and whipping this thing.
Yeah.
Hard enough to break this institutional window. I mean, it's so plain. It's really,
And
No.
I'm sure I put this in my brief, but my argument is that he threw a plastic trash can at an unbreakable window. Also, he said his intent explicitly. We know that there were several people in the pod buzzing the guards, trying to get the attention. Things were getting hostile in there. They were trying to get the attention of the guard. And then Mr. Vert put himself on the stand and testified that I was trying to get their attention. If he was trying to get their attention, again, that is not intent, specific intent crime. Did not intend to damage. Again, I'd like to say it's not like he took the trash can and hit the window 7 times until it finally cracked. He chucked, and that was it. It smashed. He said on the
Jury
stand that he was
question though, isn't
surprised.
it? Jury doesn't have to believe your client.
No, but the prosecution has to provide sufficient evidence to withstand a motion for directed verdict.
As Judge Kelly suggested, there's a video.
And that kind of ties into my next issue. One last thing on that one is, like I said, he didn't smash it over and over. He didn't throw it at the TV. There was a TV in there. If he wanted to destroy property, there was better ways than throwing a
this
plastic.
thing weighed like 4 pounds and wasn't a cheap little plastic garbage can. I mean, 4 pounds is pretty heavy.
I'm not so sure about that, but I still stand that, I believe it shouldn't have survived a motion for directed verdict if one had been made. On the issue of you seeing him on the video, that brings me to my issue about the title of the video showing Sean Burt breaking C4 glass window and the prejudice that caused for him. Appellee answers that, well, he got up on the stand and said he threw it. Well, yeah, but that's a decision he made after the bell had been rung, Sean Burt breaking glass. And I want to point,
That's exactly what it was. Sean Burt breaking glass. I mean,
the video is not, you don't see you don't see him pick up the trash can, it leave his hand and hit the window. You see, he's there kind of after, he's there kind of before. And you even see in the testimony of Sergeant Erickson, he says, you can see Mr. Burt, you see the trash can get thrown. He doesn't say you see Mr. Burt throw the trash can because it's not clear. A jury could have looked at that video and said, there was 10 angry guys in there. We don't know who threw it. Now, once it says, Sean Burt breaking the window, maybe that could have changed his decision about how to proceed when it came time to decide, whether to testify or not. So I'll move on from that.
I would.
Again, on the issue of restitution, and on the issue of restitution, Eppley says that, well, Mr. Burt didn't object. I would just leave that on a counsel, ineffective assistance to counsel for not bringing it up. And there's a couple points in Eppley's response where they fault appellant for not expanding the record on the issue of the title of the video, like if the jury saw it or and the other one is on the jury instructions, the mystery defense jury instructions that I wasn't able to get a hold of. We did motion for an evidentiary hearing and were denied in the trial court. So any fault, I would hope that the fault for not expanding the record on those issues wouldn't be on us. Does the court have any questions for me at this
No,
time?
you pretty much read your brief. We got it. Thank you. Good morning again, counsel.
Morning again, Assistant Attorney General Brent Morton on behalf of Chippewa County this morning. I'll just respond to the few comments that were made. With regard to the clothing issue, I believe there was a motion hearing on this. I believe the trial court determined that it did look like civilian clothes. So I think you need to defer that finding of fact. With regard to the intent and the claim of ineffective assistance of counsel for failing to bring a directed verdict, defendant's defense of his explanation of his intent of what he was trying to do with the trash can didn't come in until after the time that a defense attorney would need to make a directed verdict motion. So that important argument that, well, the jury didn't consider his intent, the evidence of his intent wasn't in until after the fact. So we can't blame the defense attorney for not bringing a motion without all the information that you would need.
What is the effect of a guilty verdict on a failure to bring a motion for a directed verdict, if there is any? Do you know? Does it absolve counsel if the defendant is found guilty of failing to bring a motion for directed verdict?
I don't think it does because
I don't think it does either.
it's same as a sufficient, you analyze it the same as a sufficiency issue.
That's
And
what
if this court was determined it was insufficient evidence, I think you could override the verdict. Finally, with regard to the trash can, Your Honor, I believe you're correct. There was testimony that it was a fire resistant trash can, so it was sort of unique, and it was about 4 pounds. So when he picked it up, he would have recognized that this isn't just a plastic trash can. This is going to do some damage. And
Does it really matter though, and relative to what he was convicted of? What if his intent was to get the guard's attention, or his intent was to, he had the intent to throw an object at another object sufficient to produce a noise that would alert this other person. So it seems to me it's a confession, for lack of a better word.
I
Pretty
think
close.
I think though it is relevant for a jury could, if the testimony was it's just a plastic trash can like the one right here. Well, I don't think any of us expect glass to break.
Why did we give you a trash can, Mr. Morton?
I haven't
Evan, I
used
thought
it.
we told you whenever Morton's here, don't let them have tissues, water, or trash can.
I'll take my wrappers home in my pocket. Don't worry, Your Honor. But I think that, you know, the intent would be more believable if I bang this against this plastic trash can against the window, not knowing it would break, instead of I picked up this 4-pound brick and threw it at a window. I think it's relevant with regard to the jury's determination of intent.
Okay, well, certainly there's enough facts and evidence that the jury could make that conclusion on its own.
I believe so, yes.
Anything further?
No, Your Honor.
Any
Thank you.
additional, this is it. He's leaving, so this is your last chance.
Thank you so much, Your Honor.
Always good to see you. And enjoy Nuevo County.
Yes.
Any rebuttal to that? Thank you very much. Once again, counsel, you did a magnificent job on behalf of your client, who did not give you a whole lot to work with, I would add, but you certainly gave us things to think about, and I do appreciate that. Thank you very much. Matter is submitted. Court's going to take a brief recess, and we'll come back and finish.
All right.
Good afternoon, everyone. Obviously, we saved the best for last. Maybe not. That brings it, I think we're at item, if I'm not mistaken, item number 20. Thank you. Case number 373692, Decker versus O'Connell. Not the O'Connell we know. Good afternoon, sir. I think yes, it is.
It is, Your Honors. Good afternoon. May it please the court, Alan Francis for the defendants and appellants in this matter, or appellant. I've been here long enough. I wrote my own brief. I own the typos that I discovered as I was preparing for today. So, and I'm well aware this court has.
I think what you meant to say was you discovered the typos, put them in the file, and your associate failed to make the
Your Honor, I have an email. I have an email to some people in my office correcting those. They didn't get to. No, those are mine. In any event, I know the court's aware. I want to get to sort of just the highlights of this case and where I think the fatal flaws of the court were.
All right, sir.
They were covered in the brief, so I apologize, but I just do want to highlight them. We've got the side yard issue, which I'll talk about, the area between the two houses. The plaintiff makes a large deal, number one, about the location and the orientation of my client's outbuilding. This was an area that was determined by acquiescence with the board. And that's the side building and the dike that was built when there was high water. That is not evidence of acquiescence at all. And the record doesn't support that. The record supports with respect to the dike that it was built in a location to be able to use my client's pole barn as the second wall for the dike, so they didn't have to purchase more wood. That was a third-party testimony and my client's testimony. With respect to the building, the argument is that my client orientated his building consistent with this agreed upon property line. But what the testimony was my client saying, that the plaintiff asked me to orientate my building so that the plaintiff could continue to see the canal from his home. I asked the plaintiff, do you recall that discussion? He said, I probably did. So we've got a situation where my client's trying to prevent water coming from his house or his water going into his pole barn and trying to accommodate a request of a neighbor to view the canal. And those things are being used against him to show that he acquiesced to a board in the ground and a flower line being the property line. Not only do we have that, but we also have.
I'm going to interrupt.
No, absolutely.
I'm sorry, just to my own mind to clarify.
Sure.
Can you remind me who initially placed the board there? Don't we know, or?
It was, I'll make a date. It was the 1950s, 1960s. It got pulled up by predecessors to someone of these parcels. I don't recall the exact testimony, but it was pulled up by one of the owners of the parcels. It might have been my client's grandparents. It could have very well been his, but it got pulled out of the canal as essentially scrap driftwood.
Okay.
Set in there.
But your client doesn't have an issue that the parties were using that as sort of a property line for many years.
Oh,
doesn't he?
my client testified he knew that wasn't the line. He
Oh,
wasn't sure
okay,
where the
that's what-
line was, but he knew that that wasn't it.
All right, that's what I
Yeah.
wanted to, thank you.
Yeah,
for
and and that's reflected in two things. I'll start with the plaintiff. In 2001, I talked about the outbuilding that the plaintiff had, that he wanted to continue to see the canal. So 2001, he submits permits for the outbuilding. His permits depict property lines. The property line on the side yard is a straight line that's depicted on his permit applications, not the angled line that's created by the board. So that's plaintiff in 2001. In 2006, the defendant pulls some Army Corps permits for seawall work. My client shows the straight line, not the angle line that's created by the board. So you've got 2001, 2006, both parties acknowledging that the board isn't the line. You've got defendant indicating that he was trying to stay to the line, but I think the plaintiff staying to the line. I think at most what you have, at most, is the plaintiff with a unilateral mistake regarding where the property line is. That's not sufficient to get you adverse possession. But I wanted to talk about the side yard first, because Judge West correctly ruled there wasn't adverse possession with respect to the side yard. He determined acquiescence. And the ruling with respect to adverse possession, he ruled there wasn't hostility. That's important when we get to the next section of this, because the plaintiff testified that his maintenance of the side yard area where it wasn't hostile, mowing, fertilizing, that sort of thing, was the same as the maintenance between the outbuildings, which is the next area we're going to talk about. And Judge West ruled that there was not adverse possession with the outbuildings, but he gave the plaintiff a prescriptive easement to maintain his flower bed, the outbuilding, and and access to compost bins, a weather bin, and ends up being about a 5-foot prescriptive easement. And that's important because the testimony was, again, that it was mowing, it was fertilizing, and it was walking back and forth. Those were the plaintiff's uses of this prescriptive easement area. I don't understand how you can determine those same uses to be not hostile with respect to the side yard area, but establish the hostile requirement with respect to the area between the buildings. Seems it's an internally inconsistent argument here. So I have trouble with that. There's not hostility. There's actually consent. It was just somebody using the area to walk to get to a flower bed. I mean, that's not hostile either way. With respect to that too, I covered this in my brief. I don't need to talk a whole lot about it here if the court doesn't have questions on it, but the Judge West also expanded beyond what the requested relief was in the pleadings with respect to the prescriptive easement. The prescriptive easement request in the pleadings was related to access to the outbuilding. Access to the outbuilding was created via the stepping stones, which is the next section I'll talk about. The prescriptive easement that the judge granted was with respect to maintaining the flower bed and the weather vane. So the flower bed is within the property line. He just is asking to go outside the property line, maintain it. I don't think the pleadings support that. And the evidence doesn't either. With respect to the stepping stones, there was a series of stepping stones that were admittedly in the disputed area. My client mowed over them. That's undisputed. My client testified that he knew they weren't. He knew they were on his property. He had no issue with his neighbor cutting across his property to get to and from the door on his pole barn. No issue.
But then there was a fence erected, and didn't the fence cut across the stepping stones, or am I not remembering?
No, the fence is why we're here.
Right,
My
right.
client ultimately did erect that fence.
Okay.
Prior to sort of the dispute that arose to why we're getting here, he said I had no issue with him accessing the stepping stone.
So the contention of your client was he did so with consent, correct?
No, the contention of my client is that plaintiff used that area with consent. Yes.
Okay.
Yeah. And then with respect to adverse possession, though, the testimony was undisputed. My client also mowed that area. mowed over the stepping stones, did all of those things. They both did it. I don't want to suggest that just one of them did it, but there's no exclusivity with respect to the stepping stones. There's also no decision. My client's never been displaced from that area. They're ground level stepping stones that are on the ground. Those are the general topics I wanted to talk about. If the court doesn't have any questions further than that, I'll save 5 minutes for rebuttal.
Okay,
It's
great.
amazing how many of these cases there are from all over the state. If you
Well,
ask
I
the
think-
average person, they'd be surprised how many of these fights there are.
Yeah, and I believe I could be mistaken. I believe I was in front of Judge Borello on one about a year ago, but Parsons Island, both these houses could probably fit in this room, it's a tiny, tiny postage stamp of a lot.
Well, yeah, these outbuildings are like right up against
There.
one another, and then there was the top-down view,
Yep.
and I was like, holy smokes, this is like a tiny little city or something. where These houses are just like a beach in New Jersey. They're
I
just
would
stacked.
characterize it maybe as a different country, but that might be a different story.
Where is Harson's Island?
It's St. Clair County, so it'd be south of Port Huron, sort of right before you get to Macomb County, maybe.
before Lake St. Clair.
Yeah.
What, St. Clair River?
Yes.
Okay,
Yep.
all right, okay.
Thank you. Well, look who's back.
Good afternoon.
How have you been?
I have been wonderful. I've missed the Court of Appeals.
Well, I've been asking about you. They said that you left the prosecutor's office because you didn't want to come here anymore.
No, you've gotten
That's it, and
terrible
specifically
information.
me.
This was one of my favorite roles in the prosecutor's office, but wanted
Well,
to do
it's-
something different, wanted to practice with my stepdad before he retired. So
This is
awesome.
certainly different than prosecution.
yes, yes. I described it to somebody the other day as trying to get a drink out of a fire hose. I mean, it's just civil practice is all over the place and everywhere and, brings you to places like Harson's Island. So for the record, Hillary Georgia on behalf of Kevin Decker and Denise Anderson. In this matter, I too own all of my typos as well as any complaint you may have about the record in the trial court because counsel and I both did try the case. And I think I probably have the unique privilege of having actually been to the property because my clients insisted that I see it. And the prosecutor in me likes to see the crime scene. So there I went. You're right. It is tiny, it is tight, and it is very closely held property. So I know that you've read the briefs. I have no intention of rehashing that. The only thing I want to kind of touch on are the things that counsel brought up. I'm going to start with the relief requested being outside of what I asked for in the complaint. My complaint, like all pleadings, very general, very non-specific about a lot of things. But what I did raise was the issue that Mr. O'Connell's actions presented to access to the outbuilding. And the trial court was pretty clear, and I think it's based when you look at the pictures. You have the outbuilding, you have the flower bed basically attached to the outbuilding. You have the compost bins right next to the outbuilding. But the flower bed, the compost building, or the compost bins in the outbuilding are all within my client's deeded property line. So when I'm talking about access, I'm talking about that strip of property in front of it. And in my relief requested, I did plead some things in the alternative, but also asked for any other, relief that equity would allow. And
Just to let you know,
yeah.
I'm sorry to interrupt counsel and brother counsel as well. We have in front of us your A and B. So when you're talking, if you want to know what we're looking at, this is what we're looking at.
I'm very glad you're looking at pictures because I think that frankly, the
It's
pictures
difficult
tell the
to
story.
describe, yeah.
And if I thought the video would have been, helpful, that might have been a part of it too. But at any rate,
Kelly likes videos. We give him a little
Yeah.
popcorn and a Coke and he's real happy.
trash cans slung at windows kind of video.
Wasn't that big plank being thrown through the front window of one of the people?
As it relates to the plank, since you went there, the plank was actually placed there, I believe, by my client's grandfather. So, and it was, dragged out as things float down the river and get caught up on the island. But I think the important part about the acquiescence
Bodies.
finding, hopefully not bodies, that's a whole other issue. But the
But
thing
nobody, my point though was nobody really disputes to a large degree that that's kind of a informal. I don't want to put words in brother counsel's mouth, but that was somewhere around where the property, whether it was the exact, I think he's correct. I don't think the record was was that clear, but certainly it was a point from which the parties seemed to operate. Would you
Yeah,
agree with that?
I would, and I think the board is really important because the board, something doesn't get fished out of the river and left there for decades for no reason at all. And I think that, council pointed to these different drawings that were submitted for different permits. And when you're drawing something on a paper and you're turning it over to the township, I don't really think that's dispositive when it comes to something like acquiescence or adverse possession. It's about how the parties use the property. It's about how they maintain it. It's about how they interact with it. And that board is critical because that board is, it's kind of like a level or a ruler. My clients planted a flower bed from the board to the water. My clients mowed and maintained from the board back to the outbuilding. So that board really did become over time the basis of the acquiescence claim. I think it's very important to look at that board, and that's why I sent you probably 27 different pictures of it with flowers and everything else, as well as an overhead. Because when it comes to the acquiescence claim, I do think the board matters. I think the dike that was built matters. I understand you're not just going to build a dike anywhere. You're going to push it up against your building. But that dike followed exactly along that board all the way out to the water. And this idea that the outbuilding was tilted in some way to give my clients access, I'd refer you to the overhead picture, because if Mr. O'Connell was trying to be neighborly and give his neighbor a view of the water, he did a terrible job. Tilting the building slightly still maintains the front corner, is obstructing the view. So that was one of the things that struck me first when I looked at that overhead picture. Okay, here's the deeded line. Here's the line that they have acted in accordance with for all these years, generations back in the family. And when you build your outhouse, you don't build it in line with the deeded line, you built it in line with the board. So I think.
Outbuilding. Difference between an outhouse and an outbuilding.
Did I say outhouse?
You did.
Oh my gosh, I didn't mean to. No, I don't know where that came from. There's no outhouse involved here.
Good.
Outbuilding, I apologize. That's a terrible slip.
Well, if it was an outhouse, I hope you got your money out.
Not an outhouse, not an outhouse. Anyway, so as it relates to the acquiescence, though, I do think that also what I'd like the court to take a look at in those pictures is how the grass is maintained. And this comes off as kind of a snarky comment, and I don't mean it to, but when you look at Kevin and Denise's property, they take a great deal of pride in their grass, their full-time residents. You can tell where their green grass ends and where they've maintained, and you can tell where Mr. O'Connell's grass is, because he's not there all the time and he's had, a lot going on. So I think that those are all the things, you have testimony in these cases, but a lot of times, sometimes the pictures tell the story. And I think that the trial court relied on that pretty heavily. The area of the stepping stones overlaps with both the area between the outbuildings and the side yard. And I know that counsel spent some time in oral argument and also in his brief talking about how, well, the trial court found that there was this, absence of hostility between. And so then how could the trial court then find that those elements were met to the extent of the stepping stones and the easement that was granted? And I think there's three things. There's a difference in the knowledge of the parties. And I would note too, I think I said this in my brief. If I didn't, I should have. The trial court in two different places in its opinion referenced the credibility of Mr. O'Connell and what he knew and what he didn't know. And I know that this court does give deference to those factual findings, but the trial court used the word self-serving when it came to Mr. O'Connell's testimony. And I think that's important when you look at any reliance on what Mr. O'Connell said he knew, didn't know. But for purposes of that side yard area, both parties acted in conformance with that board. There was a difference in knowledge there. There was, nobody really cared where the deeded boundary was because they always focused on the board. In the back, my client was clear that he was mowing.
I'm sorry, when you say back, which direction we going?
Between the outbuildings.
Oh, okay, that little strip.
Yep.
Okay.
Yep.
Thank
So side yard is the triangle piece, and I say in the back because
back from the water.
Back from the water. Yep.
Okay.
I treat the water as the front.
Gotcha.
The outbuildings are in the back. So when you look at that back area between those two outbuildings, my client did testify, he mowed it. He did, 2 swipes of his mower. He knew he didn't own all of it, but he mowed more than he owned. And he very clearly exerted complete control over that stepping stone area by placing the stones there. So the side yard, the parties weren't in it. They weren't using it a lot. They weren't focused on it. But that area in between the two outbuildings and that stepping stones area was heavily used by my client
daily. They're out there tending the garden, they're running compost to the compost bins, and they're running that little stone path back and forth to do their laundry in the outbuilding, which is kind of unusual, but they do their laundry out there. They bring their groceries in through there. So they're constantly on those stones. And so this,
Do their laundry in the outbuilding?
yeah, they have their dryer out there.
Oh,
I didn't clarify whether the washer was out there too, but that was significant, you know,
They
to me at
must be
least.
married. Are they married? They've
They,
been together a long time?
they have,
Well,
they have.
then somebody gets to go do the wash and gets to get away from the other one.
Yeah, well, and they drag the groceries back and forth in a wagon from the outbuilding where they park into the house. So between groceries,
Horse-drawn or motorized?
the wagon, no, it's a foldable, you know, it's like
Oh,
a
it's a-
tailgating wagon. It's
They
like
pull
a,
it themselves.
yeah, no, they unload the car in the garage, they pull the wagon through and get to the house.
Listen, just throwing this out there, got a couple horses
Okay,
that I would gladly give your client that would pull that wagon much nicer for them.
on this particular spot, I think horses would,
I don't know if they'd fit.
they would
but
not fit. They would not fit. But
Nobody wants to take my wife's horses. I don't
sorry,
understand why. that
horses
is.
are hard to get rid of.
Harder than wide, yes. Anyway, in all seriousness
Yeah.
though, what about brother counsel's contention that his client was obviously aware? I mean, this was no mystery, certainly, once those stepping stones were placed in that, but that all of this was done with his consent.
So I think consent, when you give it retroactively in the middle of a trial, is a lot different than consent that's been freely given over the years. My clients never asked him for consent. My clients treated that as their property and used it as their property. And I think that you know that consent wasn't always there when you look at the chronology, and all of a sudden in 2022, he gets a survey and then he puts up a fence that goes directly across. I mean, it boxes them out from their access, goes through the stepping stones and all the way down the side. So to say that I've given you consent all these years and then I'm building a fence, I think he really didn't have an idea as to where exactly that point was. He never maintained the stepping stones. He never used the stepping stones, because when you look at the aerial, he'd have no reason to be back there. Even when he puts things between the two outbuildings, he's not over by the stepping stones. One other thing
The boat, right, is what he
The boat.
typically.
and I think a van at some point in the past, although my clients didn't recall the van,
But it could be too, you know, and I'm sort of thinking of my own, if you will, situation where I share a border with one neighbor, and then I have a wetlands to the other side. But you know, we've both said, and probably should write it down. You know, hey, come and go, use the property as you please, with the understanding that nothing changes. You know, if you want to mow my grass, go for it, but that will not give you the right to my property. But there's nothing that would prevent my neighbor, if he says, hey, Stephen, you know, feel free, come, you know, ride your horses this way or that way, to say, I don't want you to ride my horses anymore. Or excuse me, I don't want you to use my property anymore. Right? Same with Mr. O'Connell here. The erection of the fence was his way. Could it not be construed as his message to your client? I don't want you to use them, revoking my consent. So I'm not sure that those two concepts are diametrically opposed, is my point.
I understand your example. To that point, there's two things that I think matter here about that particular area. The first one is the trial court's repeated reference to Mr. O'Connell's credibility and his ability to make self-serving statements. And I understand when he's in trial and he's saying, you know, oh, I gave permission, this was always fine. He understands that defeats adverse possession, but I see the idea that, well, I'm tired of you using my property, I'm just going to put up a fence. But that was not ever acknowledged on my client's side of things, because it was never an issue. I mean, they were always mowing that area, always using that area. He had never in any way attempted to use it, maintain it, anything of that sort, other than maybe he ran his lawnmower over it, you know, because it's a small area. So I don't think that the fence was a revocation of any granted permission. I think it was a situation where he realized that, you know, he could put his fence in a very different place than he may have thought before. And, you know, he put it in such a way that it's so obvious when you look at it, who had been, I don't really like the word dominating, but who had been dominating the usefulness of the space. It was 100% my clients. Because when you look at the corner of the fence, I mean, they can't go back and forth anymore. It almost looks ridiculous because the stepping stones go under the fence. And to that point, I just want to refer the court to Exhibit 31. And the reason why that one matters is because that's the one where the gas flags are placed. When Mr. O'Connell put the fence up, he didn't call, the gas people. They came out after the fact. And you can see, clear as day, here's the gas line with the flags, and it goes right from the outbuilding of my clients right to their house, right through the area they just put the fence up. So I do think that when the trial court made the finding of a lack of hostility between the houses, and perhaps the trial court may have articulated it a little better. I don't want to be critical of that, but there is a very different situation in the back between the two outbuildings and by the stepping stones, both in terms of what the parties knew, how the parties used it, and how the parties maintained it. Because maintaining stepping stones, maintaining a gas line, all of those are very different actions on the part of my clients. And there was a much, I believe, more forceful use of the space back there. I feel like the line is much more clear in the side yard because we have the board, we have the flowers, we have the dike. That part is so easy to see in the pictures. But the the area between the outbuildings and the stepping stones area really becomes more about what the parties were doing on a day-to-day basis. And I don't want to overlook the part where when my clients are using it and maintaining it, they are there 100% of the time. So Harson's Island is kind of one of those communities where most people just own a vacation home. They're up there maybe one weekend out of the month, that kind of thing. Mr. O'Connell is not there frequently. There was testimony to that effect at trial. But my clients are there every day. They're looking at that grass every day. They're back and forth to that outbuilding regularly. So I think that when the trial court made that finding, that there was the element of hostility in the back between the outbuildings and by the stepping stones, it was based largely on the use of the parties. I don't want to rehash my brief, so I'd rather answer questions if there are any.
I don't have any.
I think the briefs very rarely, very adequately laid it out on
Okay.
both sides. Excellent arguments, I would add.
The diagrams and photos are really useful.
Yes, thank you.
Took those with my drone.
Good to see.
On an,
You sit, you're standing right there.
I know. That's the worst part about it. You
I
don't see it
thought
on the
we
drone
weren't gonna
camera and I got it
unmask.
home and I'm like, well, there's my,
I saw that. I was like, I think that they're taking a drone themselves. I can see them.
yeah. I don't think anything helps in a boundary line dispute like a picture from above and on Harson's Island in particular, because when you get too close to what's on the ground, you get distracted. But if you look down on it, it's, I think, helpful. So.
Well, and I imagine that being an island, it's not a perfect square or in the, goes
There's
like this. and-
Absolutely nothing perfect or square
and it
anywhere on the island.
changes,
Yeah, the water levels do matter. And unfortunately, when the owners of the premises change, that's when we really see.
From eminent domain and partial takings, it's always useful to see it.
Yeah. That's why I like my drone. All right, thank you.
Thank you. Rebuttal, sir.
Just briefly, I'm not sure how an underground gas line helps to support above ground adverse possession case, but either way, I'd ask this court to think about how these uses are hostile with respect to the stepping stones and with respect to someone walking on property to maintain a flower bed that's on their property. My client didn't decide to put the flower bed against Mr. Decker's garage. He put it within his property. You don't get a prescriptive easement because I decided to run flowers up to the property line. And that's what he got here. Him needing to maintain flowers is not one of the conditions. It's got to be hostile, all those things, and he doesn't meet it there. The other thing, and I touched it on the brief, there is case law that suggests that Mr. Decker's offer to purchase the adverse possession area is fatal to his claim. That was admitted at trial. Mr. Decker admitted at trial that yes, it would be considered, or it could be considered neighborly to be mowing somebody's lawn. And Mr. Decker admitted at trial that he intended to stick to the deeded boundary line, which is also fatal with respect to the stepping stone area and the adverse possession. Thank you.
Thank you. Excellent job, counsel. Thank you both very much.
Have a good day.
You too. You sure have come a long way, Miss Georgia, since you first stood in front of that podium in front of me. How many years ago was that now?
2013.
Wow.
I could tell stories about her in
We
elementary.
went to high school
or in
together.
high
Oh,
school.
did you really?
All the
All the way
schools,
through.
yeah.
That's too funny.
Talk about ammo, we have plenty.
That's it. Thank you.
Thank you both. Again,
you.
we appreciate your submissions. Item number 21, case number 374445, Cherry Hill versus Conifer Insurance. Again, both sides are endorsed for oral argument in this matter. Good morning. Or I'm sorry, good afternoon.
Oh, it is good afternoon.
Yes.
May it please the court. Don Fulkerson appearing on behalf of the plaintiff appellant, Cherry Hill Recreation Center. I guess we've established a tradition and perhaps even a precedent at the 11 o'clock case call where we have to own our mistakes at the very beginning of the oral argument. So let me tell you, I'm mortified that in both my brief and in my reply brief, I miscite the two sections of the restatement of contracts second that I cite regarding impracticability of performance. It's actually 261 and 264, not 291 and 294. I am mortified. I am not in the practice of, particularly when I'm citing when I'm citing some authority. So I wanted to point that out.
We have a hair shirt out at the security that you can put on as penance.
I was wondering what kind, maybe, we were talking about Mahler the last time I was here. Maybe I would have to listen. I'd have to listen to a lot of Mahler or something.
Now, come on, that's not
Oh,
that
it's
bad.
just I was worried about you because it's dark music.
Well, I will actually be back in this fair city, I think this Sunday to hear a 95-year-old man conduct the ninth.
Good.
Herbert Blumstein.
I don't think you can conduct the ninth if you're under 70. I think you have to have that gravitas of life to be able
Yeah,
to.
so it should be, I mean, he's one of the all-time Mahler greats. And anyway, I happened to run into the woman who is, and her name escapes me, is the conductor in residence, and at the hotel. Anyway, I said, hey, should I go? And she says, oh, he's still got it 100%. Good for him and good for you. Now, before you begin, I got some bad info. Somebody told me you were retiring.
I am
Is this
retiring.
true?
I'm winding down, but I agreed as part of my agreement with the firm, Fabian Sklar, that I would handle cases winding down. And I thought when I argued a case called Quigley last October in front of the court, and I thought that might be my last one, but there are probably going to be one or two more. And this is just kind of carryover work that I had agreed. These are cases I've been working on for some time.
Well,
And it's a little bit perhaps an issue of closure that I have a hard time letting
Gotcha.
go or something.
That's true. I certainly will miss you, Mr. Fulkerson. Without question, you're one of the finest appellate lawyers I've ever seen.
Thank you, Your Honor. It's very kind of you to say. Thank
Well,
you very
it's
much.
true.
I wanted to point out, sometimes in the past, I might have brought in a massive poster board that had the policy provision on it, but we're dealing with, predominantly, we're dealing with section E6 of the business and personal property coverage form. It's on page 362 of the plaintiff's appendix. And so we're going to be referring to this for the most part during the oral argument. So if you wanted to refer to that.
Okay, thank you.
Sure. I'm reserving 7 minutes for rebuttal, by the way.
All right, sir.
Okay, do
you mind if I kind of just lay out a couple
This is
of
for your
questions?
benefit.
Well, I appreciate that. I don't think lawyers understand that. First of all, I would appreciate if you would start with why your client is a tenant and not an owner or lessee, or have you conceded this?
Owner or general lessee.
General lessee.
Right, because there's only three categories of insureds under the vacancy provision that apply. One is an owner. Well, Cherry Hill is not an owner. Link Group is the owner. So that's out. So they're either a tenant, a general lessee, or a category that isn't covered by the vacancy exclusion, which is, I think, likely here. They're a tenant, Your Honor, because first of all, they leased the building from the owner. And there was undisputedly, we deposed the designee of Conifer Insurance, Sean Locke, who admitted that the building had enough business personal property to conduct the customary operations of Cherry Hill. So we have someone leasing the building and maintaining sufficient business personal property. So they do meet the definition of a tenant. The argument that Conifer raises is, well, they can't be a tenant because they leased the whole building. And the policy says for purposes of a tenant, the building is either a unit or a suite. Well, that's true. It does say that, but we get into problems here that we had a long journey in this case. I don't know if the court can reflect almost this winding arc of the saga of this case, but we went back and forth. The trial court would seem to rule one way and then change the court's mind and rule another way. And during the primary hearing on November 2nd, 2023, the court was just grappling with the issue in this case. Like, okay, what is the designation of Cherry Hill? And in talking about this, the court just says that it had grave difficulty, particularly due to the fact that in the subprovision B that addresses an owner and a general lessee, there's no provision in any way referencing use by a general lessee of the building, which would support the fact that a general lessee under the policy is like a manager of the building or an investment company that leases the building and then releases it for financial purposes, not somebody that leases the building for their own use. And that's, in fact, what the trial court ruled when it said it offered a definition of a general lessee, which we agree with. It said, quote, this is at page 32 of the appendix D. It says a general lessee is a party who runs the entire property for or instead of the owner.
Right. Who rents a property.
You got it.
Yep.
Right. And the most important is the last clause, not primarily for its sole occupation. Well, Cherry Hill used 98% of the building. I mean, 700 square feet was rented to this pro shop, but 48,000 square feet it used for the bowling alley and the recreation center. And in that kind of case, they're just not a general lessee under the policy. We submit that, we submit the only reason why the trial court got there is that it just violated three rather bedrock principles of Michigan contract law. One is you enforce the policy as written. Well, the trial court not only didn't do that, but the trial court rewrote the policy to favor Conifer. The court said that a general lessee is considered to have vacant premises unless 31% of the total square footage is occupied and being used by it to run its customary operations. Meaning what it did is, again, if we're going back to this policy provision page, it took subprovision B2 and just engrafted the words or general lessee after building owner into that provision. It rewrote the policy. You can't do that. The second thing the trial court did
Well,
is
he says, again, I'm.
Oh, go ahead, Judge.
The court is saying a general lessee has control of the whole building. That's why I concluded he was general lessee.
He did say that.
So I don't think the court rather disputes that your client had control of the whole building, right?
We don't dispute that either.
Right, okay.
Right, we don't dispute that. And again, how does the policy define or designate a general lessee? We know they're a tenant, except for this dispute over suite or unit. We know they're a tenant. And again, I understand they make that argument that they can't be a tenant because they lease the whole building, not a suite or a unit. Although I think this just becomes so ambiguous and so murky. And the trial court used words like Rorschach test, cryptography, and I empathize with the trial court. I don't agree with where the trial court ultimately arrived at its conclusion, but I think this policy it just has holes. It's not just inartful drafting. It's a mess and it's ambiguous and it should be construed in favor of coverage.
Is it your client's position that the question as to what they were, be it owner or whatever, is a question of fact, or do you believe it was a question of law?
I believe it's a question of law. I mean, it is a question of law, how you interpret the policy. And they, I think that you can look at you can perhaps come up with three different types, or maybe two different types of what a general lessee might be. It might be somebody, the way the court said about not for their sole occupation, somebody that's either managing the property for someone else or buying it for an investment to release. That's what I think. This is, Your Honor, what I think Conifer intended. I think Conifer intended a general lessee to be an investor or a manager, not someone who leases a building for its own use. Otherwise, why is there no provision anywhere in this clause for use by a general lessee? There are provisions only for use by a lessee, which can't be the same as a general lessee, a sublessee, or an owner. So even if you accept the trial court's conclusion that the policy perhaps can be fairly interpreted to conclude that because they leased and controlled the whole building, which we concede, that they're a general lessee, you can also obviously fairly read the policy to say they can't be a general lessee because they occupied and used 98% of it. I mean, I do the math right. 700 divided by 48,000 is like 1.5%, something like that. So I just think the trial court, after a long journey, got it wrong. I think that the court should have granted the plaintiff's original motion for summary disposition. This is the court's June 19, 2023 order, where it said, well, they're a tenant, and the court said that the building's not vacant, but then said, well, we still have to determine whether the exclusion applies. Well, that was clear error, because if the building is not vacant, then you don't even get to the secondary issue of whether the exclusion applies. So I believe that at the inception, summary disposition on the issue of liability should have been granted to Cherry Hill, the plaintiff, and the case should have just been referred to appraisal under 528.33.1M for determination of the amount of loss. End of story. And that's our primary request for relief here. We're asking the court to reverse the denial of summary disposition in that June 2023 order and the grant of Conifer's motion for summary in the March 19, 2024 order, and a remand for entry of summary disposition on the issue of liability and referral of the case for appraisal. But there's a secondary issue. Let's just, for sake of argument, let's say that the trial court was correct, that unambiguously, and this is what the court ruled, unambiguously, they were a general lessee, which I think is clearly wrong, but let's assume they're correct. Then you've got the issue here about, all right, what about, was the premises used to conduct customary operations for at least one day within the 61-day period before the loss? Because that's all it would take to establish that the building was not vacant. Because it has to be that it's not being used for customary operations for more than 60 consecutive days before the loss.
Remind me, is customary operations defined?
Sure. The policy broadly defines customary operations as basically just your business activities at the described premises, Your Honor. And that's at page 385 of the appendix, that provision. And it's very broad. It doesn't require that the business be open for the public. It just says your business activities. And what happened here, as we emphasized in our brief, is it was a sua sponte order. Conifer moved for summary on a completely different exclusion, which I can get to, although I think it's just unambiguously doesn't apply because this is a fire suppression system, and that provision exempts it. And the court, I think, was originally going to grant summary on the basis of that different provision, and then just sat down to write the court's decision and just changed gears again. One of the many gear changes that happened in this case, and said, no, I'm concluding again. I'm relying on the vacancy provision. They're a general lessee, and I find as a matter of law that they didn't conduct customary operations within that 60-day window. And so there's two issues. One, because we didn't have notice that the court was going to do this, We filed a motion for reconsideration and attached an affidavit by Mr. Abbas, which in conjunction with his EUO, his examination under oath, he said, no. Once the state of Michigan lifted the COVID closure order, effective the 21st of December, 2020, I had people in the building cleaning it for several days. I was restocking the premises. I was dealing with issues of arranging for restaffing. I was going to open in mid-February. And we cite case law, which is not rebutted. There's no dispute that cleaning and maintenance constitute customary operations. And the policy itself is so broad in defining what could be an operation that this should have been sufficient.
Customary business operations, is that word in there?
Well, the vacancy provision, Your Honor, says yes. It says, that 60, where the damage occurs has been vacant, and it's vacant unless customary operations. It doesn't say business. It just says customary operations. And we admit it's a bowling center. It's a recreation center. It's a bowling center, but the maintenance and the cleaning is part of the operation to operate this. So at the very least on that issue, we don't need to get there if we win on the first issue. If we win on the first issue, if it's ambiguous or they're not a general lessee or they're a tenant, then the building's not vacant and we don't get there. But if we get there, there's a material fact question.
Where I'm hung up on this issue, counsel, is I have in my notes here, the defendant that the trial court said, the defendant admitted through its representative, Sean Locke, that the property was not vacant for more than 60 days before the water damage was done to the property, as the term vacant is defined in the lease.
I don't think that's correct.
Okay.
I think that, and again, I'm an officer of the court.
Yeah,
I'm being,
that's why I'm asking.
Yeah,
These are my notes, so they're probably not right.
Mr. Locke admitted that there was sufficient business personal property on the premises, which under the tenant provision would be enough to establish it's not vacant. I think the judge was eliding. I think he just elided the fact that Locke was talking about the sufficiency of business personal property, which under the tenant provision is enough.
Right.
Under the owner general lessee, that issue isn't discussed in that provision. It's, do you use at least 31% of the premises to conduct customary operations?
So to clarify, you don't take umbrage with the fact that the trial court said it. You take umbrage with the fact that Locke said it. Locke didn't say those exact words.
Locke didn't say, I admit the building wasn't vacant.
Right.
He didn't say that. He said, I admit that there was enough business personal property on the premises to run it. That's what he said.
Thank you.
Yeah. So I think that even if we get here, if we go through the various filters and we get to this point of, it was their customary operations. Remember, the COVID order lifted on December 21st. The loss is February 4th. And that's 45 days. And during that time period, there was a lot of stuff going on the premises. That should at least be a fact question. They make the argument that, well, there's no way they could have been in the building because DTE records showed that there was no use of gas. But we don't know how cold or warm it was in the building during that time. There's no evidence to rebut Mr. Abbas. And it's also undisputed that the building had something like 24 inches of insulation and was very energy efficient. And that the pipe that burst, that one fire suppression pipe, the sprinkler pipe, was undisputedly located at the far side of the building at the east wall next to an air vent above the insulation. And that's in the defendant's investigation report. That's their Exhibit E.
What's the significance of that?
The significance of that is, well, they make the argument, well, the reason the fact that the DTE records show no gas was being, or what gas was being used, and the fact that the pipe burst showed the building had to be super cold. And I'm making this point that no, the building could have been fine to do work, could have been fine to do this work to get ready to open. It could have been fine. And the fact that the pipe burst, the pipe was above the insulation.
But the area where the pipe burst must have been pretty cold.
Yeah, but it was right next, it was during a cold snap. It was right next to a wall in an air vent above the insulation. That's the point I'm making. And it was nothing else broke in the building, Your Honor. That one thing next to the wall broke. So, and then the other point, which is again, gets to my mea culpa, my errata about my miscite, right? The trial court correctly ruled at the outset that, well, they could not have been conducting customary operations during the COVID closure. Correct? Of course not. But more than 60 days elapsed between the reopening and the loss. Well, no, that was 45 days, not more than 60.
Right, it was December 18th to February 4th.
Right, or December 21st, right? That was the reauthorization date.
Right,
The order
I'm
was-
sorry, yes.
Yeah, and it doesn't have to be, the restatement rule just says impracticable. It doesn't say impossible. And if they want to make the argument that, well, you still could have maintained heat in the building, well, he was closed from the 16th of March all the way through this period, and it's a 48,000 square foot building. He had no money. He wasn't generating any business income, and it's a huge space. So again, I think the issue of impracticability would also be a fact question if we need to get there. So, as always, it has been and always is a pleasure to argue before the Court of
Well,
Appeals.
thank you. And I appreciate the way that you handled the argument. Thank you. Because it's exactly the way you laid it out in your brief. And I just wanted to make certain that I understood what you were arguing in your brief. It's a very complicated case.
It is.
I honestly am up in the air. I have no
I'm not
idea
here,
what to do.
Your Honor, and I'm not here to trash the trial court. I said, I'm going to repeat myself because I empathized. I mean, he talked about how very tough it was, like a Rorschach test, cryptography, and that's what this is. And that's why I just think I think he may have come to the conclusion that, well, maybe they didn't mean to do it this way. Well, then they have to write it. They have to amend their policy. They're free to amend their policy. They're free to redraft it. That's what they should do. A court can't write the policy for you. And that's what happened here. I'll reserve the rest of my time for rebuttal. Thank you very much.
Just one really, really fast one while you're up there.
Yeah, Your Honor.
There was statement 261, and I just pulled it up, and it's, where after a contract is made, a party's performance is made impracticable without his fault by the occurrence of a non-event, the non-occurrence of which was a basic assumption on which the contract was made. Here's the part I want to focus on. His duty to render that performance is discharged unless the language or the circumstance indicate the contrary. The duty from the bowling alley owner to the owner isn't to operate, it's to pay for the lease. So I just don't know.
It's also to comply with the vacancy condition. This is a condition. It's a vacancy condition. It's a condition subsequent. You stay open or you maintain adequate heat. It's a condition subsequent, and they have the burden of proof. It's a condition. And and Your Honor, restatement section 269, it's not in my brief, but it talks about a temporary suspension. So we're not saying the contract is like terminated. It's just when there's a COVID closure, they couldn't stay open. They were legally prohibited from being open, and they weren't generating enough income to heat the building. So it's impractical. Yeah, maybe I'm not answering your question.
No, I think you are. I think it's just, I don't know if whose obligation that is to whether the bowling owner owes that, but he's responsible for getting insurance premiums to the owner.
Well, there's a responsibility to comply with the condition subsequent by the insured, but it's their burden to prove you didn't do it. Because it is, and that's undisputed in the case. That's their burden to prove that it wasn't done. And again,
Oh, that's fine. It's a
Yeah.
good question. I'm glad you asked.
restatements 269 again talks about just a temporary suspension, which is what we have here. Okay, thank you very much.
Thank you. Good afternoon, sir. Thank you for waiting this long. Nice to see you again, as always.
And as long as we're strolling down memory lane, it's
Good to see you
been a
again,
long
John.
time since I've seen you. Mr. President.
I'll be very brief. I think our brief kind of lays everything out. with respect to the question of general lessee, I don't think this is a hard question to answer. The policy clearly states when the policy is issued to the owner or general lessee, building means the entire building. Now, the problem with plaintiff's argument is general lessee means nothing under the plaintiff's argument. This was the whole building. This guy was the one that made all the decisions with respect to the building. He was in control of the building, and that's why he's the general lessee, and that's why the trial court was right on that point. Moving to the issue of customary operations, the DTE records are essentially undisputed for more than 60 days, and we lay out right in the bills. There's like no heat in this building. I mean, there were a lot of building owners and tenants that were impacted by the shutdown, but they didn't do what this guy did, which was essentially turn off the heat so that you could have a pipe burst like this. There were no customary operations going on for well over 60 days.
Well, is there a difference between customary operations and preparations for customary operations? A business is there to make money. So
Sure.
it seems to me when you open the doors and bowlers come in, now you're, operating, but if you're
customary
mopping the floor
operations,
before
I
they
mean,
come in.
the most essential part of customary operations is that you could have a building that somebody could walk into. And if you have a building with no heat on, that's not customary operations.
Curling in there, maybe.
But this wasn't a curling center.
Okay.
And lastly, and I didn't have this case from the very beginning, but I handled it through most of the litigation part. And there was a protracted history to this thing and went on through a long time. And the interesting thing about this business of the special form exclusion is that for about 2 years of litigation, the plaintiff fought every step of the way that they were maintaining operations, that they were doing something to maintain heat in the building. All right. And then right before we got to trial, all of a sudden they said, we're not going to contest that anymore. And I just remembered when we had one of the earlier hearings that Judge Sullivan said there's a question of fact as to whether or not they in fact maintained heat in the building. And when all of a sudden they conceded that point, I was like, well, golly, we're going to file a motion for summary disposition based on this exclusion. And that's what we did. And I said, look, there's no dispute of this now. They didn't do this. This business about, well, except for fire protective systems is nonsensical. That's an exception to that exclusion, which means that if there was a fire and the sprinkler system went off, that then for that reason, there would be coverage for that water. It's nonsense to say that that exclusion applies here. What we have is a circumstance where, look, this guy did not do what he was supposed to do. And that's why you had this water loss. Judge Sullivan made the right decision, and took him sometimes a ways to get there, but
And candidly, that's what's causing me some, because I have to stop at each rest area and get out and look around.
It was a long journey, Your Honor. Thank you.
Thank you. As always, excellent brief, counsel. Appreciate it.
Good points. First of all, he's question begging. He's question begging. He's saying, well, it's obvious that they're a general lessee without discussing or rebutting any of the points. That's question begging. He's just assuming they're a general lessee without explaining to you why are they a general lessee? Why are they a general lessee when the policy doesn't provide for their use and they use 98% of the building? The second point is, this is all their primary appellate strategy is just bad optic, bad optic, bad optic, bad optic, bad optic. It's the only arguable relevance to the issue of the heat in the building is, okay, was the building sufficiently habitable to to do things in? And we have an unrebutted testimony that the building was heavily insulated, it was energy efficient. We don't know, there's no confirmation that it was freezing in the building except above the insulation at one time right near the edge of the building, and everything's unrebutted. And I guess I got to read this. This is the other exclusion that they relied on at the very end, that the trial court was going to grant summary on and then decided he couldn't. It says,
You reading from the policy?
I'm reading from the policy.
Okay,
This is page 368, 369 of my appendix.
thank you.
We will not pay for loss or damage caused by or resulting from any of the following: water, other liquids, powder, or molten material that leaks or flows from plumbing, heating, air conditioning, or other equipment, except fire protective systems caused by or resulting from freezing. His argument is, oh no, this is only intended to apply to a situation where there's a fire and the sprinklers go off. Well, when the sprinklers go off in a fire, that's not because of freezing of the pipe, that's because there's a fire.
Hopefully.
Hopefully. Thank you very much.
Thank you. Guys, I hope I get to see you at least.
I hope again. Oh, I made the other point about I guess I was going to make one more point. I'm sorry. This was a Judge Talbot pet peeve. I don't know if you remember this. Though, when you say you're going to say two things, say two things. That you can't construe a policy to reach an absurd result. And the way the trial court in Conifer is reading the policy is, you've got insured who rents the whole building and is using 98% of it, but by definition of the policy, the building's vacant because it's not being used by an owner, a lessee, or sublessee. That's absurd. Thank you.
Thank you.
Thank you very much.
Thank you both. I really appreciate your submissions and arguments, and thank you for your patience. Thank you very much. Matter is submitted. That brings us to item number 22, case number 374368, Baird versus Kazali. And I if I mispronounced, I'm sure counsel will correct me. How are you today?
Fine, thank you, Your Honor. May it please the court, Sherry White on behalf of the defendant appellant, Officer Kazali.
Nice to see you again, Miss White. How have you been?
I've been fine. How
Have you really?
Yeah.
Okay, good. This is a tough case, you know, I mean, you always do an excellent job and I certainly appreciate it. But why wouldn't it be a question of fact for a jury whether a police officer changing lanes and not looking and not using a signaling device, whether that is a question of fact as to that being gross negligence?
It's not a question of fact because of the much higher level of negligence required for gross negligence. Conduct so reckless as to demonstrate a substantial lack of concern for whether an injury results. There's, as I described in our brief, there's a pretty big gap there between ordinary negligence, which is at best what this is, and gross negligence. Finding that this was gross negligence would pretty much erase that distinction. And the distinction is there for a reason. So
you might not want to, but you would not object vehemently if I said, yeah, this is negligence. It's just not gross negligence.
That's not been determined yet, but the issue here is not whether it was ordinary negligence or not.
Right.
And I assume they have the city of Detroit's the defendant, and they have a motor vehicle exception.
Yes, that's not the issue here.
It doesn't really make any difference if she's in or not, right? I mean, they're still suing for the accident.
Well, the city of Detroit is a defendant.
Right.
But the
the
point here is this motion was.
Governmental immunity, you have gross negligence, but you also
Right.
have the motor vehicle exception.
Correct.
So I don't understand.
But that's not the issue here.
I know that's not the issue, but I'm
Yeah.
saying to them, what do they care if this case gets dismissed because it's not gross negligence? They still have a case against the city because their vehicle was used that caused a negligently caused accident. Maybe that's why they're not here.
The city upon approval of city council does represent and indemnify individual employees in lawsuits such as this.
If they're grossly negligent, yeah.
But those employees regardless of what the status of the city's liability is, are entitled to this gross negligence defense under the Governmental Immunity Act. And this motion was brought solely on behalf of Officer Casali. So the issue in front of the court is, was this gross negligence? And the point is, the definition of gross negligence is not just higher than ordinary negligence, but significantly
Pretty serious stuff.
higher.
Yeah.
And the legislature wrote that for a reason.
Cases have
So
upheld that.
at best, we have an improper lane change. There's no evidence of gross negligence, so we would ask that the circuit court order be reversed and that summary disposition be granted to Officer Casali.
Any other questions of council? Any questions? Thank you again, Ms. White. I hope you have a wonderful day.
You too. Thank you.
Thank you very much.
Thank you.
Matter is submitted. Item number 23, case number 378274, in re TEB. Good morning, or excuse me, good afternoon. How are you? I'm well, thank you. You're all alone.
Okay, I wasn't sure if she was appearing via Zoom.
I don't think anybody's appearing
Okay.
by Zoom today, so.
Well, Jennifer Bruggeman on behalf of the petitioner, I would probably then just,
Are you, because you don't mind me asking, are you a contract attorney? Do you work for the AG or?
I work for Lenawee County Prosecutor's Office.
Okay.
But our office
That would have been my
handled-
third guess.
Yeah, so
Well, thank you
this
very
is
much for
my
coming.
one and only mental hearing appeal so far, so I'm hoping to keep it that way. But
When you were working on it, did you say, what kind of jerk judge would find that there's a right to effective assistance of counsel in these cases? And then you discovered that you would be appearing in front of them. You don't have to answer that.
No, I actually agree with that.
So you came all the way from Lenawee County?
I did.
How long a trip is that?
Today it was right on the money. Didn't run into any issues, so it was about 1:20. But I was early, so because I never know, because sometimes it's taken me 2 hours. So yeah.
That's about the same time it takes me to go to Saginaw, so I would have thought it would have been longer, unless maybe you go a little quicker.
No,
No, you,
not-
as a
I'm pretty
prosecutor,
good,
you
pretty
always
good.
observe the law, don't
That's
you?
right. That's right.
Absolutely. Well, here, again, the problem with these cases, and I don't want to generalize, but is that these are people who are making complaints and we're not certain where they are in terms of their treatment. So, are they in a place where mentally where we can acknowledge that what they're saying is probably true, or are they not? And it just seems to me that, what they're complaining about here, and I sort of understand the argument. The argument, I think what happened, and I don't know if you feel free to correct me, is I think what happened here is they wanted resolution of the matter, and the client, the respondent, was being a little difficult and not being able to acknowledge the need for treatment and so forth and so on. So it sounds as if they kind of came up with, if you will, a compromise. And I don't mean that the court was involved or even that your office was involved, but it seemed to me that is between the lawyer and the respondent. He said, well, look, what about if we agree to hospitalization, but I ask for, if you will, an update or a review. I think it was within 45 days, if I'm not mistaken.
Correct.
And then I'm not entirely sure about the record here. Was it that he didn't ask for it, or I think he did ask for it at the time that they entered the agreement. And I think the trial court said something to the effect of, kind of, and I can obviously paraphrase, we'll cross that bridge when we come to it. In essence, I think in fairness to the trial court, said, let's see where the respondent is. Is that pretty much what happened?
I would say so, but I would say a few things. In this case, he has been, this is the third appeal, within
Right.
the last couple years. This obviously was the longer order. The other ones, by the time we got here, it was moot. So this one expires in, I believe, September. And yeah, I mean, but to your questions, I mean, the bottom line is the record is what we have, right? There was no motion filed in probate court asking for a Ginther hearing. There's no motion in this court for a remand. Now they're asking for a remand for that because I think they acknowledge that there really is no record here to kind of know what happened. I think the record does support some of their arguments in terms of that the certificate wasn't filed, saying that he met with that council met with
Right.
the respondent.
Or it was filed late or something like the day
Yeah, so
after.
there's some, I guess, arguments like the record is lacking, but ultimately, I think we have to look at also why the respondent was asking for that review. He was mostly concerned about his meds and the effects that they were having on him, not the fact that he even acknowledged on the record that he needed treatment. So he wasn't up there saying, I don't need any of this, like, I don't need you guys, et cetera, et cetera.
Saying,
He
I
was
want to do
saying,
it holistically.
well,
I think
and he
those
was
were his
saying like the
words.
meds that he was on were having these negative effects on him in terms of gaining weight and things like that. So that's on the record that he was to
That
meet with the
explains it.
doctor on Monday after the hearing. So we had this record saying, okay, well, you're stipulating to this continuing treatment. We will acknowledge that you want to review, but you're also going to the doctor on Monday. Let's see where we're at. You can always file a petition. You can talk to your attorney. The attorney said on the record, he has my cell phone. We can talk about this. And beyond that, who knows what discussions were had? Who knows if the respondent tried to call him, et cetera, et cetera. So I think, though ultimately I would disagree with a remand here, but because we are where we
Yeah, I don't
are,
think that would be necessary.
I don't think that it's outcome determinative just based on how things have played out. But I mean, ultimately, yeah, I would ask the court to.
I would agree. I think that's fair. A great analysis, actually. I think there was probably some ineffectiveness here, but I don't think that the respondent can overcome the prejudice prong. Nothing would have changed. I suspect that the best case scenario is he may have been entitled to have somebody ask for a review after 45 days, but there is, to your point, which is very well taken, they didn't provide us with any information that could possibly lead us to conclude that it would have had any effect.
Right.
It's their burden, not yours, right?
Right. And like the idea of that 45-day review wasn't foreclosed, it was presented as the judge was open to it. So, and I don't think that everything that was, and the respondent did testify at the hearing. It wasn't as if his attorney put this stipulation on the record and then no testimony was given. The respondent was given an opportunity to speak his piece and what his concerns were. And I think the judge thoughtfully and, ruled the way she did and left that review option open. So I really feel like the way that the testimony came out in the hearing and how it was presented was effective, counsel. And, but beyond that, yeah, we don't know what was happening behind or like in the hallway or whenever they met. I mean, there's nothing other than his declaration, which he submits in the appeal, but that's not part of the record. So, yeah, but in any event, I'd ask the court to affirm.
Now, was it you that I asked about Adrian and the courthouse? That's what I thought. You and I had that. That was just a month ago, wasn't it? Last month, or was it?
Probably, yeah.
Yeah.
I've been here multiple times and over in 2026. So
We white guys tend to all look alike. I get that, but. So
I wouldn't
now,
say that.
Where are you going for lunch today? That's.
Well, I'm probably driving home because I have baseball this afternoon. So, just.
You have
co-
baseball or?
Well,
one of
not
your-
me, my 16-year-old, so.
Is he
yeah,
a good
got a
baseball
doubleheader.
player?
He is. He's a better football player, so hoping take that somewhere.
You know, as a mom, do you have a problem with him playing football, or are you okay with it, or? I know a
Not
lot of
conceptually,
parents.
but just, yeah, emotionally sometimes, but not, no, I mean, it's his passion, so.
One of my best friends, their kid, they forbade him from playing football and said, you can go play soccer. So you can imagine what happened his first game, he broke his leg.
Or concussion, yeah. I mean, I think the likelihood is.
So anything's
Is
dangerous.
there. Yes, exactly.
Any questions of council? Good to see you again, as
too.
always. Have a safe journey home. But
Thank
I would encourage you to get a nice lunch here, put it on your account, charge it to the good people of Lenawee County.
I'll let our chief know.
Or Judge Kelly, he runs a tab at like the London Chop House and, places like that.
Perfect. I did go, before I came here, I went to the Fisher Building and got coffee and a pastry, and it was delicious, so, yes.
Are there many places in Lenawee County that are known good places to eat? Cause in Saginaw where I live, it's like Applebee's or Chili's, that's it.
Yeah, it's somewhat lacking, but,
But it's small town living and
Yeah.
that's.
I mean, the nice
sometimes
thing
the
is you have
trade-off.
Ann Arbor nearby and Toledo and,
Yeah.
yeah. So there is a new restaurant in Brooklyn called Atlas, and that one's really good.
Is
So-
the track in Lenawee County?
Yeah, well, it's partly in Jackson, partly in Lenawee, so it depends
did
on
not
where
know
you're
that.
at. Hmm.
Son of a gun.
Yeah, yeah.
Oh,
We were
interesting.
happy when Faster Horses.
Oh, I bet you probably got a lot of work out of that. Was that just a country thing or? Okay, but there were a lot of problems, I remember.
I miss it. But I like
He
country.
was one of the problems. Thank you. Have a safe journey back. Always appreciate you coming, and I know it's not an easy trip, so we do appreciate it.
Nice
Thank
to
you.
see you all.
Take care. That brings us to item number 24, and I see Mr. Marshall back there. Case number 375-435, In re Eldridge Vassar Minors.
That's Mr. Marshall.
I'm sorry, I was calling that. I didn't see Miss. Item number 25, 376-900, KK Hicks minor. That matter is submitted. I meant to say I didn't see. Okay. No problem. Now we're here on 376-901, correct, sir?
That is correct.
Good, I got it.
900 is a companion case that I think was just called and submitted, and 901 is the one you just called.
Correct,
That is
and
my
that's
case.
your
That's the
case.
That's the father's appeal?
Yes.
Yes, so good afternoon, your honors. My name is Joshua Kay. I am
There
here
we
from
go.
the Child Welfare Appellate Clinic at the University of Michigan Law School, and we represent the.
Well, we're
appellant
sorry to
father.
hear you couldn't go to Michigan State, but
I-
that's your burden.
I apologize.
Well, I want to apologize. Thank you for waiting. That I know it's not fun to sit there for all this time, and not only thank you for waiting, but thank you for coming. It means a great deal to us. We wish it would happen more often. And I also want to remark, if you will allow me, that we very much appreciate the University of Michigan and the law school and what they do in these matters. And you folks, and you in particular, have really elevated the level of shall we say, representation for people who, are looking to lose their children. So we appreciate it very much. Thank you.
Thank you for saying that, Your Honor. And I very much enjoy sitting and listening to the arguments in various areas of law, 98% of which I don't practice and haven't. And I appreciate seeing the court operate during that time. So it's very much my pleasure to be here. I'm not going to belabor my brief. I think we and the students on this case who unfortunately were not available to handle today's argument, it is finals. and
Ah,
that is how it is. So I am here, but I think they did a wonderful job looking into this case and briefing this case. I'm not going to belabor that. We briefed two arguments. One is the reasonable accommodations argument, right? That reasonable accommodations for Mr. Hicks' psychiatric disabilities, which were known to the department and known to the court, should have been made. And without that, termination statutory grounds should not have been found. And then also we made a best interest argument that it was not in the child's best interest to terminate, that relative placement was not weighed against termination as is required under Michigan law. And in fact, a guardianship was readily available. And here the relative was equally open to guardianship. The relative who had placement of the child was my client's sister. My client actually found the placement for the agency. The agency did not find her itself. He found her. It was working very well. She was maintaining contact with my client and maintaining contact between the child and my client. So all of that was happening. And she, while she was willing to adopt, she was equally willing to enter into a guardianship. And I think that Michigan law, particularly under In Re JMG, which we cite in our brief, says that, you know, if any relationship would be beneficial to the child, then it might not be in the best interest for the child to have a termination. I do want to focus, obviously, I'm open to questions
yeah,
on any of this.
if you don't mind, because
Please.
this is an issue that we get a lot, and it pertains to
Yes.
the first issue that was raised, which is the duty of accommodation here. Here we seemingly, and please correct me if I misstate anything, but seemingly have a respondent father here who has some issues with taking medication and so forth in order to, you know, be able to actively participate in his shall we say, development to be reunited with his kids. What specifically do you believe that the state should have done that they didn't do in this situation to facilitate that?
That is a wonderful segue, Your Honor. I appreciate the question. It's exactly what I want to speak to.
Oh, okay.
Here. So the testimony was that my client was steadily under the care of a psychiatrist, saw the psychiatrist monthly, and was taking his medication. That was never disputed by the agency. And in fact, the agency at the termination hearing admitted they had never spoken to the psychiatrist in the entire pendency of the case. In fact, the caseworker admitted in her testimony at the May 27th, 2025 termination hearing that she hadn't even approached my client to get a release of information to speak with the psychiatrist. So one of the things that I think really needs to happen in these cases in order for there to be reasonable accommodations is they have to speak to whatever practitioners are working with the person who has the disability. Those practitioners have knowledge, they have expertise oftentimes, and they may make really good suggestions about what to do. Another thing that should have happened is that there should have been a thorough assessment of parenting capacity. This is not a mere psychological evaluation, though even that wasn't referred, again, testimony of the caseworker, until 3 months before the termination hearing. But
You
even
said, I'm sorry.
yes, please.
Thoroughness account of parental.
A thorough assessment of parenting capacity.
Thank you.
So what would that look at? It would look at areas of current weakness, just parenting skills. It would look at how stressful does the person find parenting? There's actually a psychological measure available to do just that. It would look at areas of weakness, learning capacity and learning style, and it would yield recommendations for how to proceed in a case. Obviously, if you follow those, if the department does that, they follow the recommendations and the person doesn't benefit, either need to look at, is there more to accommodate, or do we need to actually move on, maybe terminate parental rights? This disability is not a shield against termination. I'm not asserting that.
Right.
Clearly, but it does require accommodation. I think that thorough assessment is a key. Another thing that should have happened here, that I think would have been amazingly useful, would have been referral to a parent partner. The court had ordered that, and the agency never did it. Again, admitted by the caseworker in her testimony at termination. A parent partner is a parent who has been through the system, successfully got their kids back, and can serve as a bridge and as a mentor to a parent that's currently in the system. That might have been the thing that connected my client more thoroughly, got him more involved in the case. Again, trial court ordered it and it never happened. And then this is a fact that concerned me as soon as I looked at the record in this case. The agency complained a great deal that it's hard to contact my client. His phone number sometimes changed or went out of service, that kind of thing. But it was undisputed in the case that the agency always knew where he lived. Always.
Well, he says he got it and he just wasn't going to participate unless it was convenient. for him.
Sometimes that's true. And it may have been his way of phrasing it. The agency also admitted that it never really sat down and talked with him about how serious the case was. Despite having him in a team decision-making meeting early in the case. They said we never covered that.
So you had 3 out of 143 visits or something?
It is true that he did not.
143 chances, that's.
Yeah, Your Honor, it's absolutely true that he didn't visit on the schedule that the agency contemplated, absolutely. But actually, he was in contact with the child at other times, and the agency admitted that, to their knowledge, those visits went well, and the child was bonded with him in a positive way.
Total of 15 visits over the child's 4 years of life.
There was testimony early in the case, the child was about 1 when the case began, and that he had had 10 to 15 visits with the child during his first year of life. That's where that number is, as far as what that number was, as far as I remember from the record. But at any point, the agency could have gone to the house that he lived in steadily with his father for 15 years, or when he got an apartment, he told the agency exactly where that was, and they never went to that apartment either. So they didn't make any effort to go connect. And so I would assert that they didn't meet their duty to make affirmative steps to ascertain his needs and accommodate his disabilities. So that's the termination statutory grounds argument. As I already mentioned, the best interest argument, we had a relative that actually wanted to maintain the contact, was facilitating contact. That contact was going well, though not on DHHS's time, was going well. Child was bonded with him. That was a positive relationship. And so I would assert that under those conditions, it's not in the best interest of the child to terminate particularly.
But he didn't bother to go to the best interest hearing, did he?
Correct. He missed a number of hearings. That is correct.
Including the best interest one.
I believe that is correct. Exactly. I think that, yes, I just double checked my notes on that because I want to be accurate for this board. Absolutely, yes. I just want to make sure I'm on top of it. Absolutely. I think that there could have been more involvement, but again, in Ray Hicks Brown, in relation to my client in that case, requires affirmative steps, specifically that the agency, and this is basically a quote from Hicks Brown, can't be passive in its approach to ascertaining a disabled person's needs and accommodating those needs. And I think that the agency was very passive here, and that's a violation of what's required. If there are other questions, I'm happy to hear.
No, if you don't mind, I'd just like to state on the record that we received from Casey Humbert, Humbert, P number 83089 yesterday.
Yes, I received it too, Your Honor.
Their brief. I have on numerous occasions warned Mr. Humbert to file his responses on time because it's unfair, to put it nicely, to you, because now you have a right to respond. So what I'm going to tell you is we're not going to review his brief. We're not going to accept it.
Okay, I appreciate that clarification, Your Honor, because I was debating
I
whether I need
figured
to
you
file a
were.
reply.
we will no longer tolerate this kind of nonsense out of the AG's office. Certainly those people like yourself who are inundated with numerous clients having to file these cases within a certain time frame. If you're able to do it, I do not understand why the state's largest law firm can't do it as well. And this is inexplicable and it's inexcusable. So I'm not apologizing for him. I have no sway over him at all. I'm telling you, you do not need to respond because we're not going to read it.
All right. Thank you, Judge Borello.
Thank
Really
you.
Appreciate that. And thank you all, Your Honors.
Thank you
Appreciate your
again,
time.
sir.
Absolutely.
Now, I will tell you, you know, Judge Kelly and I both went to what was DCL. But I don't think Judge Ackerman could get in there, so he had to go to some out-of-state school. What was the name of that, where you got your law degree?
Columbia.
Columbia, yeah.
I've heard of it, Judge. Yes.
Yeah, it's used to be a truck driving school. Thank you very much.
Thank you very much. Appreciate it. I hope you have a good rest of your day.
Thank
each
you.
of
You too, sir.
Thank you.
That concludes our call. Oh, I'm sorry. Oh, yes, I do. I apologize. Item number 26, case number 366612. That's telling. People versus Stodgel. Nobody is endorsed for oral argument, and that matter will be submitted on briefs. Kevin, thanks a million.